7:30, and the regular meeting of the City Planning and Zoning Board on October 1st will come to order. Preliminary matters, additions or deletions for our agenda. Tim?
Mr. Chairman, the staff has no changes.
How about the board members?
None.
None. Seeing none, we'll move on to approval of the minutes. I'd like to has everybody had a chance to read the minutes from the August 20th meeting?
I have.
Is there any corrections?
You know what? There were some typos in here, and I didn't get them all covered. I wasn't sure just how significant it was for us. But on page 2, about halfway down through, about a quarter of the way down through the applicant presentation, there's a word subsistent. I think should be maybe significant. He said there is just one important subsistent difference. I'm not sure. I don't know if that's a legal word or not.
Substantive. Yeah.
Substantive, or
Yeah,
okay, so that
probably
needs to be changed. And then in the italicized print, there's a responsibility for administrative off the code. Maybe it should be of the code. And at the bottom of the page, the next to last sentence, the word is repeated. It should be it, probably. Is that it? Is? That's the extent of what I have here.
I caught all those too. I just didn't want to mention it.
I know, and I didn't know how significant it was, so okay, thank you.
Is there any other corrections to the minutes? And we're looking for a motion, please.
Approve the minutes.
Do I have a second?
As amended.
Pardon me?
As amended.
As amended, thank you, as amended.
Second.
All in favor, say aye.
Aye.
The second one we have to approve is the regular meeting minutes from September 3rd meeting of 2015. Has everybody had a chance to review those?
Yes.
Yes.
Any corrections?
On page 9, the second sentence, Mr. Dake's comment, upkeep of the holding area would be bored by the airport. Should that be borne by the airport?
Yes.
Okay, then that would be what I amend.
I'm fine with that.
Approve the minutes as amended.
Second.
All in favor?
Aye.
All opposed?
Thank you.
Thank you. At this point in time, the board will open up for public comment. If you have comments to make, you can make them now, or you can make them when the individual item comes up that's on the agenda. Also, under the first item coming up, though, there is no public comment available on that. Is that correct?
That's right.
So if you're here for item A, there'll be no public, it will not be open to the public. But can they speak now, Peggy?
You can speak now on anything else that's coming that you want to bring up before the board, but nothing as to A, B, C, or D, because those will all have comment. B, C, and D will have public comment allowed, and A has no public comment. So please, unless it's other than those 4 things, something else having to do with planning, then you can come up and speak. Otherwise, wait until those items.
Okay. Well,
Yes, sir.
if anybody else would like to have one, if you'll raise your hand, we'll see that you get them to you. I'm going to reiterate, because you didn't have this in front of you right now, there's 4 items on the agenda. The first item will have no public comment during that particular question. The other 3 will have individual public comments where the public can make comments during the presentation at a certain point. So, anybody not understand?
Yes, I have a question. Why is there no public comment on A?
He has to come up and ask the question.
Yeah, you have to, during public comment, you can ask that question. We're going to open it just a second anyhow, okay? All right, we'll move forward then. Now we're open for public comment. If you'd like to make a speech or have a question even about that, feel free to come to the podium, but it has to be from the podium so we can all hear it, okay, and be recorded.
I just have a question.
Please state your name.
My name is Randy Rudish.
Okay.
Why is there no public comment on A?
On the first item, because it's an appeal of the planning director's interpretation of the land development regs, and it's just not open to public comment. It's just between us and our attorneys.
Okay, thank you.
Sure.
Any additional public comments? Please come forward. Okay, we'll go on to the first item, which is an application number A15000005 submitted by Barry G. Siegel, PA, appealing the Planning and Development Director's interpretation of the city code pertaining to guest house and transient quarters. And you going to make the presentation?
If you could ask for disclosure of any ex parte.
Yeah, ex parte. Does anybody have any information for ex parte?
I don't.
No.
No.
No. Swearing of all applicants. So anybody that's going to speak before this, please come forward and be sworn in.
You raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Attorneys don't generally need to be sworn, but thank you, gentlemen.
If there's any exhibits, they should be to our clerk now. And Tim, you're going to make staff presentation?
No,
There's
I
none?
didn't swear in. My legal counsel will be doing that.
Okay. So then you'll make your presentation.
That's correct.
Go ahead.
I believe the appellant.
The appellant first? Okay. Applicant's opening statements. Okay. Forgive me. That's reverse on Peggy. It says staff presentation first.
Are you looking at C?
No, it says A right here in the front.
No, but we're supposed to be. We're there's because it's a little variation on this one. Okay. I apologize and forgive me. I'm just out of step here. 1 second. Okay. The applicant presentation is first, and so please speak.
Thank you, Mr. Chairman, members of the board. My name is Barry Siegel. I'm actually here on behalf of John and Robin Norkus. I'm an attorney here in town with my office at 3096 Cardinal Drive. We were here before recently on a similar related matter, allowing this appeal to go forward, and we appreciate the opportunity to have this before you. This is just our opening statement. At this point, to make it short and sweet if we can. This is a matter that involves an interpretation by Mr. McGarry as the planning director for the city of Vero Beach as to regarding to a vacation rental. I am aware that this board has already heard cases, or at least one case, and has made a pretty dispositive ruling based on an interpretation of Mr. Gary on a very similar circumstances. I am not going to sit here and re-argue that position. I think it would be fruitless, and that is not our purpose today. Our problem is a much more underlying issue with regard to the ordinances. Originally, if you had this violation, you would go straight to the Code Enforcement Board. And in fact, in the past, for example, the Carroll case, that went to the Code Enforcement Board and subsequently there to the Circuit Court where that matter was resolved. It is my understanding in response to that circumstance that the city changed its procedure to allow, and this is under Section 2-303 of the code, that the city reestablish a new process to say if we've got interpretation issues, we're not going to trust the Code Enforcement Board, a board much like yourselves, just different people. We're not going to trust them to make interpretations. We're going to send those interpretations to the planning director. And then if the planning director will issue what the city's position is and interpreting this ordinance that you might be finding a violation with or you might find an issue with. And that is our issue, is that this is an improper delegation of the authority of the city council as a legislative body. I've got two issues with it. One, it's allowing Mr. McGarry, no disrespect to Mr. McGarry, an excellent employee of the city and really a tremendous asset of the city, that allows him wide berth to make an interpretation of the code provisions, which is then allowed to be appealed to you, but it comes to you cloaked with an authority of the city already, whereas it should be, and it is totally removed from the Code Enforcement Board for them to allow for an understanding. But more importantly, we are looking at an ordinance that is so vague that it requires an interpretation to be moved forward, and I believe that that's a fundamental violation of my client's due process, that you've got ordinances here that are so unclear that they require an interpretation by the administrator officer, or in this case, the planning director. And so there is where we have our issues with it. Because we have a purely legal argument, you have the benefit of not having to listen to witnesses today. You do have the unfortunate of having to listen to me then for our presentation. Because there are no witnesses, I have no actual evidence. It's all purely legal argument. At this point, I don't know if you want to defer to the opening argument for the city in this case, and then, or if you'd like the abundance of the argument that we have, just some references to some case law and reviews of the city code provisions.
I don't know how to answer that one.
Would you prefer to go ahead and give your presentation now?
Well, actually, pursuant to the procedure, opening statement by the appellant is followed by the appellant's witness presentation.
Okay.
And so, again, we don't have any witnesses.
He
We
has
don't have
no
any per se
witnesses.
evidence.
He
It's
has no
purely
witnesses.
a legal argument.
Again, I would just suggest that the argument be made.
Please step to the microphone so we have you on record, please.
I would just suggest that the entire presentation by the appellant be made at this time pursuant to procedure, because once I put on my presentation, appellant would then be limited to rebuttal of that.
Do you have more presentation, Mr. Siegel?
Just a little bit more in-depth discussion of the
Okay.
code provisions and a reference to a little bit of case law to the extent that the court can. A couple of the legal issues I'd like to bring to the court, the board's attention. The Florida statute dictates code enforcement board procedure and establishment. While code enforcement boards are not mandatory, the city of Vero Beach, of course, has adopted a code enforcement board. I'm sure you're all very familiar with it. And so there are a bevy of statutes then that jump in and discuss the procedures if you have a code enforcement board. And Florida Statute 162.06 specifically addresses that, and it says if there is a violation found, the code officer, after giving notice of the violation and opportunity to cure, will set the matter for a code enforcement board hearing. Florida statute, in my opinion, makes it clear if there is a code enforcement issue, that matter goes to the code enforcement board. It doesn't go to the planning director. It doesn't go, no disrespect, to the planning and zoning board. That matter goes to the code enforcement board, and the city has its remedies if it doesn't like the action, just as the parties have their remedies if they do not like the remedy or the result of the code enforcement board. So I think first and foremost we have to make some deference to Florida Statute 162.06 as that lays out the procedure with code enforcement board. I do have copies if either of you want. I have one for the record, or one for you, Peggy, if it's...
Mr. Siegel, we have opted out of 162. I don't know if you know that. We have our own code enforcement board procedure
Okay.
that's outside of the statutes.
Okay. But I think it still provides informational guidance as to what should take place with it, with the code enforcement boards. Our second issue is that there are a list of items in the ordinances that describe what the planning director should do, and that's section 65.06. And those things are things like to serve as a professional administrative staff to the Planning and Zoning Board, to as staff to the Historic Preservation, to update and maintain the comprehensive plan, to maintain and protect review files, things along those lines that are not interpretive of the code provisions. And then we have one entry that allows him to be review and make recommendations on amendments, to render official interpretations of the comprehensive plan, future land use map, land development regulations, and official zoning map. And this is the one that certainly we're here because of, and this is the one that gives me the most issue with due process and the delegation of improper authority, is that this has now taken the authority, the power of the City Council as a legislative body. And I understand that the checks and balances that we learned about in civics class and social studies growing up don't necessarily apply in the same context as they do in a municipal situation, but you still have the Florida Supreme Court that tells us that the legislative powers of the City Council or the governing executive legislative body should not be delegated without some form of restraint, limitation, description as to what it should be. And so if you looked, for example, at all of those items that are in 65.06, they're very specific items that do not require the subjective nature of an individual to make interpretations of the code provisions. They are things that are more executive in nature. And for that reason, we don't object to, of course, to those items, but this newly added power, when taken into consideration with 2/303, it does create this improper delegation of the legislative power. We believe that should be kept either with the City Council or, as we argued before, with the city's Code Enforcement Board. And so our arguments here today is that this delegation of the authority to Mr. McGarry is improper, that it should be rested with the City Council, that the power to interpret should be left with the Code Enforcement Board and the appellate provisions that are provided in that realm, and that this is an improper delegation to Mr. McGarry, and that this matter should actually be sent directly to the Code Enforcement Board for enforcement issues. That's our argument.
Any questions?
I have none at this time.
Just
Thank
ask
you.
for rebuttal after the city's argument,
That's
please.
fine.
Members of the board, good afternoon.
Good afternoon.
My name is Nick Zabrozny. I'm an attorney with the law offices of Frost Vandenboom, and I'm here on behalf of Mr. McGarry. If you give me a second just so I can get this turned on here. Thank you. As a preliminary matter, I did provide 5 documents that I would like the board to consider as evidence here today, and one of which being Mr. McGarry's decision in this matter, and I did provide a copy for all of y'all's consideration. But I do want to begin by saying that one of the documents that I did provide is a composite, and that is this board's two decisions unanimously affirming Mr. McGarry's decision in 2 related cases. That would be the Fitz matter and the Wagner matter. And in fact, Mr. McGarry's decision in each of those matters are attached to those orders affirming his decision. And I would certainly suggest that the decision in the Fitz matter is nearly identical to the decision at issue here today, being that it involves the operation of a guest house and transient quarters in an R1A residential zoning district, which is single-family residential zoning district. I also want to just begin, as I did last time, by reiterating the scope of today's proceedings. Mr. Siegel referenced Section 2-303 of the Vero Beach Code, and pursuant to that section, when an individual receives a citation, that individual can request a hearing in front of the Code Enforcement Board. They can also appeal the code enforcement officer's interpretation and application of the applicable code provisions to the planning director, which is what was done here. Mr. McGarry issued a decision as to the code enforcement officer's interpretation and application of the relevant code provisions. Mr. Norkus then appealed that pursuant to Section 64.04 to this board. So the scope, again, is Mr. McGarry's decision as to the code enforcement officer's interpretation and application of the code provisions. What was argued here today by Mr. Siegel is procedural issues. He disagrees with the procedure. He has argued that there is some form of improper delegation of authority, but all of that is well beyond the scope of the appeal that was taken. So I want I ask the board to recognize that and to understand that. As I indicated, Mr. Norkus received a citation for operating a guest house and transient quarters in the R1A zoning district. And pursuant to the Vero Beach Code, it's unlawful for any building to be used in a manner that is not permitted in that particular zoning district. And in fact, the code provides that no use shall be allowed in a zoning district unless it's specifically permitted by the code. And that's section 60.11 and 60.06. And I have today, so the question, the inquiry really is, are guest houses and transient quarters, is that use a permitted or conditional use within the R1A zoning district? Now, provided in the packet is a copy of 61.02 and 61.03, and I know I'm going to step away from the microphone, so what I'm going to do is I'm going to put these up on the board and show you on the overhead that 61.02 are the permitted uses for the R1A zoning district, and 61.03 are the conditional uses, and you will see that neither the permitted uses or conditional uses set forth guest houses and transient quarters. So as you can see, the first is permitted uses, R1A zoning district, guest houses and transient quarters is not a permitted use. And again, in 61.03, guest houses and transient quarters are not conditional uses in the R1A zoning district. And that's really what this inquiry is here today. Was the code enforcement officer incorrect in his interpretation and application? And then Mr. McGeary incorrect as his decision in relation to that interpretation and application of the code provisions? Now, I know, as I've indicated, this board has already decided the matter, and I'm not going to belabor that issue, but because it is Mr. McGeary's decision that's being appealed today, I think it would be proper to just briefly analyze that decision. As I indicated, y'all have a copy, each of y'all have a copy of that, but I just want to reiterate that Mr. McGeary's decision, one, is very straightforward, delineates the basis for his decision, and it shows that in coming to the conclusion, which you will see on the bottom of the second page, it says, in consideration of all the foregoing, it is my interpretation of the relevant code sections that the use guest house and transit quarters is not a permitted or allowed land use in the R1A district. In coming to that conclusion, Mr. McGeary relied on the plain meaning and the common understanding of the words and terms set forth in Chapter 60 in the guest house transient quarters definition, particularly the terms transient and temporary. And if you look at the bottom of the first page of Mr. McGeary's decision, you will see reference to transients and giving effect to the plain meaning of that term by referencing the Webster's Dictionary, which the term defined as one that is transient, transient guest, passing through or by a place with only a brief stay or sojourn, staying somewhere only a short time. Thus, in the context of the reference code sections, a transient is a person or guest that is only staying for a brief stay or only a short time. This comports with a common understanding and usage of the words employed. If you go down, not the following paragraph, but the second paragraph after that, the decision continues with analyzing and giving effect to the plain meaning and common understanding of the term temporary, which is lasting for a limited time or intended to be used for a limited amount of time. In other words, not permanent. Thus, use of the term temporary care and lodging reinforces the nature and characteristics of the subject land use guest house and transient quarters as limited in duration. And folks, that is the extent of the decision. That's what Mr. McGeary relied on his decision, and similar to what has previously been in front of this board in very similar matters, I would ask that this board affirm Mr. McGeary's decision as to the code enforcement officer's interpretation and application of the code provisions. Thank you.
Thank you. Any questions? Board have questions?
I have none at this time.
None.
No. Thank you. The applicant has a chance for rebuttal.
Thank you, Mr. Chairman. As I stated, the first thing I think I said is we're not contesting the opinion per se. And we're certainly not up here under the idea that there's something I'm going to be able to say magically that's going to change this board's opinion. It's what it's done in the past with regard to those issues. We're not contesting the nature of what was contained within Mr. McGarry's opinion. What we're stating is that there's an improper delegation of the authority to Mr. McGarry to do this, and I think it might be helpful if I can cite, this is a 1972 Florida Supreme Court case, and it's styled as the City of Miami Beach versus Fleetwood Hotel. I'm just going to pull one line out of it that might help. Unrestricted discretion in the application of law without appropriate guidelines and determining its meaning may not be delegated by the City Council to any agency or to one person. And that is what our concern is here today, is that the City Council has taken its laws, which may mean different things to different people, and they've given one person that unbridled delegatory authority to make a ruling as to what that means. Due process should allow a citizen to be able to read the codes and the laws and the ordinances and make a determination or understand or be placed on notice as to what that means. And if it can't be done, then it's up to the City Council to write those properly or correctly, or for a court or for a board to make interpretations as to what those mean. Our only concern is that this matter has proceeded to Mr. McGarry as opposed to the Code Enforcement Board for his interpretation. We're not arguing what he put down on that paper. We're not arguing what you have said in the past. We're only arguing that that procedure was improper and that is an improper delegation of the City Council's legislative authority to one individual to make those rulings and those determinations. And with that, we ask that the matter be determined that this case proceed straight to the Code Enforcement Board. That's all we're asking. We're not arguing about what 61 and 60 mean. We're not asking you to revisit that, and I'm certainly not here to try and convince you other than what you've done in the last two times. Thank you.
Well, I have a couple questions of you now.
Please.
2 points. It was indicated that from the other attorney that you didn't appeal to the zoning board. I'm sorry, to the
Code Enforcement
Board. Why didn't you choose to do that?
I've got 2303 in front of me, and it says that you must send your interpretation. If you have an argument that is as regard to an interpretation, that you must send that directly to the planning director. And that is my understanding from what Mr. Comment has told me as well. When this initially, we did seek to put this in front of the Code Enforcement Board because this was actually my first venture, and since the ordinance was changed for this procedure, that it traditionally would have been a code enforcement matter. But it was explained to me that, no, it's got to go to Mr. McGarry if what you're doing is challenging the interpretation of something. And so I don't know of any provisions in 2303, and I have it here, that would say otherwise.
He's accurate about that.
Accurate.
But I have a couple of questions, if you don't mind, if I could just ask. Because your appeal application to the Planning and Zoning Board, which is in the packet, states that the subject of your appeal is the interpretation of 60.11 and 61.02 as they relate to the definition of guest house and transient quarters. So having that appeal application in front of this board with no other indication that there was anything different, now suddenly we're hearing that what you're really interested in is the checks and balances system at the city. And I would posit that the fact that the city council passed the very ordinance that set that into place, and that we are now at an appellate hearing before the Planning and Zoning Board, perhaps to go to the city council, that is the check and that is the balance.
Well, what do you refer to as going to the city council?
If you're not happy with what you hear here, you can now go to the city council and appeal at that point, and then to the circuit court.
Well, I think that the problem is with the interpretation. If it was an interpretation where I could call up and I'd say, Tim, what's your opinion on this matter? And he would give me his opinion that would have no authority over subsequent boards, then I would agree with you. But his interpretation comes cloaked with the being the voice of the city, and it comes as an edict or an order for lack of a better word, that must be appealed as opposed to it being just an opinion letter that I might get from the Attorney General's office or something like that. And so I think that it is an improper delegation, that it does have a check back to the, in my case, my opinion, the P&Z board. And I don't know that I have a right to go to the city council on that, but
Yes, you do.
But it would still be, I think that the authority on it would be the Code Enforcement Board or the City Council themselves, not Mr. McGarry.
I don't think that it's abnormal that land use development codes have the Planning and Zoning Board the Planning Director as the entity who makes interpretations of the code.
I would believe
every code I've ever seen has had that in it.
I agree with it for certain. I would agree with it for zoning and planning matters. I don't know that I would necessarily agree with it for code enforcement issues, but I mean, certainly you swim in this water more than I do. But yes, I think if for a code enforcement issue, it would be proper in front of the Code Enforcement Board or this board, as opposed to a single individual.
Oh, I just will have to agree to disagree.
I might have another question for you. You mentioned something about the Miami case, and then you read a statement, but that was just one sentence out of something that's in context. I don't know how to interpret that, because if I read you one sentence, I don't think it gives me enough feeling to make some impact on me of how I should be interpreting that.
It was actually a relatively lengthy case. In that case, the City Council developed a rental program, a rental assistance program, and it delegated the authority to the, in that case, I believe it was the planning director, to determine how that would be parlayed, how that would be enforced. And so it's not a exact factual case, but we rarely get those, have the benefit of that in case law. And so part of that opinion, the reason why I didn't read certainly the whole thing, is a lot of that opinion dealt with the validity of that ordinance with regard to rent control. Was that preempted by the state, whether it was properly enforced? But then that sentence was, in my opinion, the kind of the keystone of their argument, that you couldn't delegate it out to one person, the city's authority, without having some kind of delegatory duties and descriptions, and more importantly, if you look at that entire list of all the powers that Mr. McGarry has in the ordinances that are more ministerial or more executive, this is the one that becomes legislative. And so that's why that case, what I told that statement to be, and what I hold the holding from that case relative to this matter to be, is that this legislative nature of Mr. McGarry's actions, it cannot be delegated.
Neither Mr. McGarry's counsel nor myself have had a chance to review that case.
I understand. And let me ask you another question. In 65.6, I think we talked, that's where it pretty well defines what it says. And I think we've been over a number of times interpreting it, and it seems like there's a consensus of people of what the interpretation is. And was my understanding before this meeting that we were once again reviewing what that particular statement makes and then how it's interpreted. And I haven't changed my viewpoint, and that, as you so well stated, but the only thing that I think has changed right now is whether we should be going to the Code Enforcement Board with this, or you want to stay with us with this to follow through. And did that make sense? I don't know where he's going. Because
yes, but as Mr. Siegel said, he doesn't have the opportunity to go to the Code Enforcement Board. He's in the proper venue.
Okay.
Right now.
He cannot go to Code Enforcement Board right now. Is that correct?
Not until he gets his decision made.
Okay. All right.
Mr. Chair, if I may.
Sure.
The appeal application that's in front of us is dated 7/20/15, and the writing got cold here towards the end. Subject of appeal requested. I can't quite make out what it reads, and I'm going to ask our city attorney assistant to please read it.
Yeah, I read that a little bit earlier. It says, interpretation of 60.11 and 61.02 as they relate to Chapter 60 definitions of guest house and transient quarters.
And cite the relevant city code, please.
60.11, Chapter 60 definitions, and in parentheses, guest house and transient quarters.
Thank you.
I have I don't know if it's a question or a comment, but you had basically talked about the power being invested in the planning director skipping the code enforcement board. But then at the same time, you talk about the list of duties that the planning director is responsible for, and that includes the comp plan, comprehensive land use plan. And the way I see this is that it's appropriate to put this particular land use, what's allowed and what isn't allowed, in the hands of the planning director. Do you have any comment about that?
I don't believe it belongs there in a code enforcement context. I think in there's certain circumstances, if I send in or a client of mine sends in an application that they want to build in a home or something like that, and they need to see something that is, what are the setbacks here? Does it apply to a pool? Does it apply to a single-family residence? Can I put a multifamily home in this area? But those are not code enforcement contexts, and that's where I have an issue. Is he's interpreting this law, for lack of a better word, this criminal presentation with regard to an ordinance that is not more along the lines of the comprehensive plan and development side of it.
So you don't see this as really a code enforcement issue? I mean, you see it more code enforcement as opposed to land use planning and how that's used?
Yeah, I do.
Okay.
I was basically going on the same premonition as you are, that you stated you would go to Mr. McGarry if it was a zoning and planning issue, but that you feel this is all in code enforcement. And in my opinion, it's also a zoning issue because that area is zoned for residential use and not for transient guest house rentals. So his interpretation, in my opinion, is that he interpreted the code the way it reads in that residential district area.
And I understand, but the distinction I make is this is more of an enforcement issue. And so I make that distinction as this is trying to enforce them as opposed as a code enforcement violation, as opposed to a straight planning and development idea. And frankly, if I'm building a structure or something like that, it's going to be a different context. It's going to be an entirely different process. We're not sitting in front of looking down the barrel of a code enforcement violation in those situations. Those are just means of kind of building a home and developing in some manner or another, as opposed to an enforcement issue. And so that's where I have the distinction.
How would you expect the city to go forward if they didn't go forward in the procedure that they had?
Well, this matter has already been once in front of the Code Enforcement Board, which is what's precipitated many of these changes. But I think that process was the appropriate process for it. I think that the City Council was less than thrilled with the result that was obtained, but that was the law at the time, and it worked, and it was an efficient delegation of the duties in a manner that I believe is afforded under the Constitution and with the due process. That's what I think there should be done here. This was changed. The rules were changed, and the cheese was moved to get a different result.
Any additional questions?
I have none.
Then thank you.
Thank you.
So you have the right to rebuttal.
Just briefly, I'm not
Okay.
going to sit here and belabor the points. I will just highlight something that Mr. Siegel said, and that is, I'm not here contesting the decision or the interpretation. And I know we've already read into the record the appeal application, but with that statement alone, and considering what I already said initially regarding 2-303 and 64.04, then there was no authority for Mr. Siegel then to be here to make the challenges he is. The basis for that authority is contesting the interpretation, the code enforcement officer's interpretation and application of the code provision, and then Mr. McGarry's decision as to that interpretation. So that is the only rebuttal that I have. Thank you very much.
Do you have any additional comments? Summation?
No, I do not, Mr. Chairman.
Okay. Do you have no summation then?
No, I think everything's pretty much
Okay. Board discussion, I believe you moved to then. Is there discussion among the board members?
No.
I think then having a feeling that I think we need a motion to affirm Mr. McGarry's decision.
So moved.
I will let somebody else make. You want to make the motion, honey?
Yeah, okay. I move that we, based on competent, substantial evidence presented and the applicable code provisions, we support the planning director's decision.
Do I have a second?
Second.
Mr. Chair, on the
Yes.
discussion.
Sure.
This particular code's been on the books, and Mr. McGarry makes reference to that on page 3. The regulations since 1977, and he goes towards there's a middle paragraph there. It talks about an effective date prior to pre-exemption date or emption date of June 1, 2011. Reference the Florida statute. It has not been preempted. The code's been on the books since 1977. I think Mr. McGarry, in his interpretation of the code, is quite clear. Thank you.
I just think that what the council has done in terms of establishing the process, I think what they've done is correct. I don't see a point in, questioning what they've done. So I'm supporting the legislation that the council has provided.
Additional discussion? I'd like to call for the vote then.
Mr. Degg?
Uphold Mr. McGarry's interpretation? Yes.
Mrs. Hillman?
Uphold Mr. McGarry's decision.
Mrs. Manous?
Uphold Mr. McGarry's decision.
Mr. Lawfer?
Uphold.
Passes 4-0.
Thank you.
Mr. Chairman, for the next hearing, we'll be using Form A. Yes,
This
sir.
time
Yes, sir.
Okay. The next item to come before the City Planning Zoning is a site plan application number SP15000008 submitted by Schulke, Biddle, and Stoddard LLC to allow the construction of an 11-unit residential townhome located at 4700 Highway A1A. And in this case, are there any this planning and zoning member ex parte communications?
None.
No.
I have none also. Swearing of the applicant and staff and all witness collectively.
If anybody's going to testify, if you'll stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All exhibits are to be the city clerk. And who's going to make, Sherry, are you going to make staff's presentation?
Yes, I am. Thank
Okay.
you, Mr. Chairman.
If you'd like to proceed.
Thank you. The proposed project includes construction of 11 residential townhome units, each approximately 3,400 square feet in size, including detached two-car enclosed garages with guest houses above them, common areas and easements, and other associated amenities and improvements, which are located at 4700 Highway A1A. The site is a location of the former Surf Club Hotel, 100-room Surf Club Hotel building that was demolished. The project also includes a concurrent minor subdivision plat application for the 11 individual lots, which is the item, your next item on the agenda. Attachment A to the staff report provides a project description and a fact sheet, including all the general background and the site information on the project. And we've also included some of the site plan materials in your backup, and they're also on the overhead screen here. Right in front of us is the actual site plan for the project. I do want to mention that this project required a neighborhood meeting, and that meeting was held on June 24, 2015 at 6 p.m. And there were 12 attendees that signed the meeting list, and we provided, the applicant provided a copy of all the required advertising and the meeting list, and we also attached the minutes to your packet of that meeting. As with most projects, The staff reviewed the site plan and as per Section 6410 of Code of Ordinances. And one of the approved site plans must meet general review, performance, and development standards. The staff finds that the proposed site plan meets all those standards. And in particular, we've highlighted two of the more appropriate and relevant standards, such as use, design, and layout of the development and project, which are all in compliance. And I'd like to just highlight, in particular, the staff did route the project to all the applicable departments: Public Works, Fire Department, Health Department, Water and Sewer, all the relevant departments. And all the departments, including the planning staff, have found the site plan to be in compliance with city codes. The site plan meets all the open space, setback, landscaping, parking, and all the other development regulations. The stormwater improvements are consistent with our stormwater ordinance, and actually the project's going to consist of a dry retention system, which is connected to an underground chamber system located north and south along the east side of the subject property. The traffic impacts, even though this project did not require a full traffic study because it didn't meet the threshold of over 100 trips per day, we wanted to make mention that the traffic impacts should be considerably less because, as you recall, there was a 100 units hotel with a restaurant there now, which approximately 1,177 trips for that use. With this new proposed use, the average daily trips is 64. So that's a considerable amount of less traffic impacts with the new proposed project. Staff also wanted to mention that the proposed improvements include some improvements on State Road A1A that have been reviewed and approved by the Florida Department of Transportation and the county and all the applicable agencies. The improvements also include a 5-foot wide sidewalk on the north property line extending to the south property line along A1A. And the project's also going to construct a pedestrian beach access with a dune crossover. The project is also proposed to meet all the necessary sea turtle protection lighting regulations, as this project, as you know, is near the Atlantic Ocean. The staff finds that the site plan isn't compliant with all our land development regulations, and we also looked at the site design performance standards for the project, and have also found that based on our analysis, that the improvements in the townhome units really are a continuation of the existing residential condominiums along that area. To the north of the project and south, there are existing residential condominiums, and staff finds that it's compatible with surrounding land uses. The project will be removing 2 driveway access points and will be constructing 1 centrally located driveway in the middle of the site. The proposed layout and the entrance of the entrance meets the city and state design requirements. The staff finds that the proposed site plan is compliant with the performance standards of our code. The staff, based on those findings, we are recommending that you approve the site plan. And there are the general comments that you see on a typical site plan, such as construction, grading, and drainage. The other condition that we have is that the applicant will comply with the sea turtle protection review, which they've agreed to do. And then also we've conditioned that the approval be subject to the minor subdivision application approval, which is the next item on your agenda. With that, I will answer any questions, and Be glad to answer any questions.
All right, questions, Honey?
Yeah, on the LDRs, you mentioned underground chamber system for the dry retention for stormwater. Could you tell me what an underground chamber system is?
I am not a drainage engineer, but from what I understand, it's underground, meaning it's not above ground. And on the top, it's the dry retention, and there's exfiltration trenches. But more than that, I would defer to the
So this is something that the stormwater is intended to settle down?
Correct.
As opposed to draining out into the ocean, or?
Correct. All the drainage will be on site. That's a requirement of our code.
Okay.
Yes, that's correct.
The pedestrian beach access with dune crossover.
Yes.
Is that public or private?
From my understanding, it is private, but I would have to verify that with the applicant.
Identifying it on the map, and it
Right.
looked like maybe between several of the units.
Yes, it's
There might
actually,
be-
if you don't mind, if I can stand up
Yeah.
and show
Yeah.
you on the actual application where it's located. It is right here.
Okay.
You know, as you know, here are the units. There's 3 townhomes here, 2, 3, and 3. This is A1A, and this is north and south. This is the Atlantic Ocean, and here are here's the dune crossover here.
Okay.
Okay, great. So that would be the only place that they're permitted to cross over. You can't trample down the.
Correct. And
Okay.
It'll be sea oats or something like that on it, on the dune.
The road in front, the private road that's being designed, the access road, is that 1 or 2 way? I couldn't figure that out either.
it looks like it is. I'm going to look on the larger set of plans just to verify it, if you don't mind. Just a second. It looks like it's 2-way, but
Yeah.
You can tell by the parking they've got to have.
it is. It's 2-way, yes.
It is 2-way.
Yes.
And then the egress and ingress is going to be mutual then, on both ends?
Yes, correct.
Okay.
Are you done, Ms. Manus?
Okay, thank you.
Thank you.
Yeah.
Back to when Mrs. Manus was talking about the pedestrian beach access with dune crossover, and above that it talks about the 5-foot sidewalk. That 5-foot sidewalk now is for public access. I know it is, right?
Yes, that's
Okay.
correct.
Is it possible, because when you have that above there and you're reading through this, some people would read through it and assume there's going to be a pedestrian beach walkover and where the general public can use it. I'd like to add it's private, and if you could put that word private in there, so when people go through and read this, it comes up as private. So I'd like
Sure,
to make that change.
we can make a note of that if you all
It
agree.
is private, and that needs to be clear.
Okay. I do want to mention, if Ms. Stegg, if you're
Yes.
done, Tim pointed out that as one of the conditions, an additional condition, because the site is in the AO special flood hazard area, we will require the applicant to submit elevation certificates. So that's an additional comment that should be
Should
there.
that be added to any recommendation?
We'll do that as part of the conditions. We do that with anything that requires
We do.
a
Does it need
special
to be, any
flood.
motion that comes up, does it need to be a part of it?
Well, you just say as amended by staff, and anything else comes up during this hearing.
Thank you.
I have one more
Sure.
question, please.
Take your time.
Thank you. The total height of the building,
Yes.
and I'm going to ask for the height from the crown of the road to the top of the building. When you stand out in the middle of the road to the top of the building, what's the height?
Okay, the building height, and they're 2 separate buildings, but I'll review the highest one.
yes.
Correct. Okay, the building itself measured from the eave. The tallest one is going to be 24 feet. Then then they're proposing an additional 10 feet of roof. So the total building height with the roof is going to be 35 feet approximately. Okay. As you all know, the total permitted height in the zoning district is 50 feet. So the project is well under that required height limit requirement. The finished floor elevation proposed for the buildings closer to the ocean is 16.7 feet in elevation.
Thank you.
You're welcome.
And just for the record, C, 1A, tourist, commercial, C, commercial, rentals allowed?
Yes, that is correct. Hotel motels are allowed, and guest quarters and transient quarters are allowed.
Okay, and that is for the record. Thank you.
Yes.
And
You're welcome.
I just want to point out, though, the density is being done as residential, even though they could do short-term rentals. Or if they were like a hotel, they could try to do 30 units an acre, and they can only do 15 as a max. So they're certainly under that.
But that doesn't preempt the ability to.
No, not in a C1A zone.
As opposed to the last person, this is a legal use there. Okay. Any additional questions of Sherry?
I have none.
The applicant like to come forward then and make your presentation? Joe, please state your name and were you sworn in?
Yes, I've been sworn in. Hello, for the record, my name is Joseph Scholke with Scholke Biddle and Stoddard of Vero Beach, Florida. I'm the civil engineer on the project, and also Vic Lombardi is here. He's the owner of the project, and the name of his company, or the actual entity, is 4700 A1A LLC, and he's here as well. I don't really, I didn't prepare a presentation. I think it's pretty straightforward. It's been a pleasure working with staff since the early summer. We did have a neighborhood meeting. I think it was well received by our neighbors. We answered all the questions and concerns they had. I can tell you probably one of the concerns a lot of people had was, drainage and how would that impact things, because the drainage doesn't work very well out there now. But, as you might appreciate, it's an existing 100-unit hotel. That site's almost paved from the north property line to the south property line with no drainage, and it all runs right into A1A. And so we're retaining just about almost 100% of the stormwater on that site within small dry retention areas, the depressional areas in the grass between our front wall and the driveway. But we're also retaining it in very large underground chamber systems, kind of on the behind the northernmost unit and the southernmost unit. They hold a lot of volume of water. They are designed so that you won't even know they're there. There'll be grass over top. It would look like just a nice grass and vegetated yard. But they're large chambers that are about 30-inch diameter. They're like a semicircle, and there's a bunch of them next to each other. They're all perforated, and then they're surrounded by a trench of rock. These fields are about 80 by 150 foot. So they fill with water, both of them, and they all percolate into the ground. So you're going to see a tremendous improvement to the stormwater in A1A. The other thing, a concern, was the traffic, and I think staff hit the nail on the head when they said, there's, the reality is there's going to be a drastic reduction in the traffic to this site. Certainly, some people might say, well, that hotel wasn't generating a lot of use in this, but it could be, or if it was ever renovated, and you'd see a lot of traffic, or could be a potential a large traffic generator. We only have 11 units. It's estimated about 70 trips per day, 64 or 70, I think Sherry said. So there's not going to be much traffic. But also, this site has, we're modifying the turn lanes. We're going to have a right turn lane dedicated into the site. And then there's also kind of like a bidirectional left turn lane or a center lane into the site. So you're not going to have people backing up into the main travel ways as well. So, we're really going to fix the traffic, so you're going to see a vast improvement. I did want to add, for the record, we are removing 2 driveways and adding 1 main one. There is a secondary driveway on the very north property line. It's actually stabilized grass, but that's only provided to the City of Vero Beach utilities so they can get to their electric transformer and a public lift station, which we're constructing for them to serve the site. So it's kind of not temporary, but a driveway that's just stabilized grass. It's not used by anybody but the utility department. But there is a second driveway.
That's on the north side?
Yes, on the north side, right at the north property line. I took notes and
Yeah, I see it right there.
honey, I think hopefully as soon as I answer your question about the drainage, but if you have any more, I'd love to discuss it with you. The pedestrian improvements, we are building a 5-foot sidewalk along A1A from our north property line to our south property line. That sidewalk also turns and goes into our subdivision parallel to the entrance road. So we're building that. The dune crossover is private. I mean, yes, it's private. It's not open to the public. It's in the center of the site on the beach. The project is walled and has a gate. It'll be designed very nicely, and I think it's consistent with the walls and the gates you see in that area. The driveways are two-way driveways. You've got a very large entrance driveway. It's extra wide so that if someone is at the keypad to open the gate, a guest, an owner can actually go past them to the right with their clicker and get in and not be held up. Also, it's wider so fire trucks can get in, or large vehicles, or delivery vehicles. They have enough room to turn around in that driveway and not have to go into the site. So we made it wider for that reason. Once you get into the site, it's a 24-foot wide two-way driveway that goes to the north and to the south. We met with the fire department to make sure that they were okay with the access, and they liked the way we provided the access, where we provided the fire hydrants, and we actually provided extra fire department connections so that if in the event of a fire, there's actually connection points behind the buildings for them to connect hoses to fight the fires from the back as well. So we think it's a really well thought out project. We think it's going to be an asset to the city of Vero Beach, and I welcome any questions you have.
Yes.
I have just two questions on concerns from the neighbors to the meeting, and one has to do with the dune access. They asked for a keypad access. Is that going to be provided where there will be a code to get to the crossover from?
No, the dune crossover that we're building is private, only accessible through by the
HOA.
by the people in our
By the HOA.
right by the HOA.
Okay, because here it said they would like it to be secured with a beach access keypad, and
Oh,
that's,
where does that say that?
that's on page 2.
It's in the meeting minutes,
Yeah,
Joe.
in the meeting
It wasn't-
minutes.
It was just a question, wasn't it? More than
Yeah.
It was a question.
Yeah,
Oh,
it was
no,
a
no, no. You
question.
know what that is? The neighbors have their own dune access. Is there a place I can point to this, or is it on
Yes.
the computer?
Use the mouse, Joe.
Oh,
That's the
okay.
only way they would.
They actually already have their own dune access right here.
Oh, okay,
It's not public. It's not ours.
okay.
It's for the development across the street. It is their dune access. It's there and it exists right now. They were just talking about working with my client when we build our wall to actually maybe build a wall and all that there. But it's that's what that conversation was about. It's not actually part of the project, other than it's right next door to us.
Okay, and one of the other questions that they proposed here is, will there be a central location for the garbage receptacles? And the response was no, there would be individual trash cans like a single-family home.
Yes.
So my question is how is that going to be taken care of through the city?
The city of
pickup?
Vero Beach,
Okay.
they'll come pick up the solid waste just like in front of single-family homes.
Okay.
They'll come into the development and they'll drive up and down our road. And remember these projects, each townhome has a two-car garage with room to contain their own trash. They'll just pull it outside of the garage door for pickup.
Okay.
And I just want to point out, solid waste reviews the site plans too. So every
Very
so
good.
to make sure that they can be served properly.
Very good. Thank you. That's
They
all.
approved that request, yes.
I have a question about the seawall. There's an existing and a proposed seawall. Outside of a little difference in the location on them, could you tell me what the new seawall is going to be all about? What it's going to be made of and that kind of stuff?
Yes. The new seawall, I believe, I should probably ask my client because I'm not sure of the material. My partner actually designed it, who's not here, Bill Stoddard. Is it steel or concrete or vinyl? Okay, it's a composite seawall, and I think that's going to look. It looks a lot like a steel corrugated seawall, but it's composite material, and it'll have a poured concrete cap on top of it, and it'll have dead men that anchor it back into the soil behind it. That seawall is going in the approximate same location as the existing old wooden seawall that's there now. I know that Mr. Lombardi and my partner Bill Stoddard have been working with adjacent property owners on extending it to connect to theirs so that it's all contiguous. And the actual seawall permitting, it's under review with DEP. However, I can tell you that this project is not, in our mind, contingent upon the seawall being there or not. It's an option that the developer has to build the seawall, but we have a stable beach behind us. We're not building right up to the line, and we should be in good shape.
Okay, thank you.
I have a question of the engineer, please, Mr. Chair.
Sure.
When you do your improvements out on A1A, you show a little bike lane there. Your improvements are just for the turning lane. Will you be improving the bike lane, making sure it's marked clear? Or is that not part of your work?
Oh, no. We will be milling the entire right turn lane. We're going to go from the if you will, the northern direction through lane of DOT at that white stripe to the east, which includes that bike lane and the existing turn lane. We'll be milling all of that, resurfacing it all and restriping it all. And the DOT wants us to bring it up to 2016 standards as far as the bike lane marking.
My other question, since you're doing the sidewalk also, what did you guys take a look at lighting, for the sidewalk and bike path? How are you going to handle that?
We really haven't addressed lighting outside of
your project.
Of the project. We have lighting inside, internal to the sidewalk. Internal to the project. We haven't proposed any lighting out in the street. There are some limited street lights out there.
It's limited lighting.
But we have not addressed it with the DOT or the city.
Okay, you might, for your future reference, you might want to take a look at that, especially go over when it's dark out. Since you are going to have people living there, turning in there, you're going to have people using the bike lane and the sidewalk, from your project.
Right.
So maybe you want to take a look at how it's lit.
Yeah, I can tell you that there is lighting in our entrance that goes out. So at that conflict point that you just said, it will be lit. But as you go further north and south, there may be need for some lighting.
And you might just want to bring that to your people's attention. Especially if you're going to have more pedestrians, you're going to have a nice project there. Obviously, people want to go out and take a walk. And you might take a look at some of the period lighting that's in the city's inventory.
Very good. Thank you for the suggestion. Mr. Lombardi's here, and I'm sure it's noted. And I have to imagine that he may be considering lighting along the landscape buffer, which is next to the sidewalk anyway, and it will be lit. But I think that he'll consider that, and we can work with him on that as well with the building permit application.
Thank you. I'm good.
Any additional questions to the applicant?
None.
Joe, if you'll stand by, though, we can sit
Absolutely.
down now.
I'm here to answer any of the questions you have. Thank you.
I would now like to take the time to turn to the public. If you have comments to make about this project, anything you'd like to have your board know about, please come forward now. Seeing nobody coming forward feel free to come forward, sir. Were you sworn in, sir? No, come on, it's all right. We'll swear you when you get up here, no problem. And please state your name.
My name is David Segala. I'm on the board of directors at Seaway Condominium.
Let me swear you in before you.
I'm sorry.
Right here. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
And this is kind of ad hoc because I didn't expect to speak here. But we've been working with Stoddard on the seawall and connecting it to the Seaway seawall, and are very pleased that went through our engineering company as well as Stoddard, and we're really happy with how that's going to work, and very pleased that they're going to be next door in this development. But beyond that, I just had a question because a comment was made about the zoning and the zoning permitting hotels and short-term stays, and that's still in effect. And my question is, does the individual condominium documents supersede that requirement? And I'm thinking about short-term residential, short-term renting.
I don't know that, but
No. Restricted covenants may supersede if it's more restrictive, but they can't be more liberal. If if it says you can't do vacation rentals in the zoning, your restricted covenants could not allow that. So does that answer your question?
I think so. In
Yeah,
other words, if our documents say that you have to rent, you can't rent for anything less than 3 months or 6 months.
And that would be the covenants would be
Okay.
the.
Right, they'd be more
very good.
restrictive,
Yes.
so they would govern.
Yeah.
Okay, right. Thank you very much.
And that's for each association, correct? And that has nothing to do with what's before us, correct?
Correct.
Okay, because they'll draw up their own
Right.
condominium.
We have no impact on that.
We have
Correct.
nothing to do with that.
The zoning is there.
Right.
And they can make it as liberal as we are right now with the city.
You had another question, Mr. Chair.
We have a question.
Please come forward. Okay, come on.
Your name?
Joanne Mafucci. I'm for the board of directors at Riverwalk.
If you'll raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Well, at Riverwalk, we're delighted to have this project across the street from us. We have an issue. The dune deck that you were speaking about is ours. We have deeded access. And we're hoping that Surf Club is going to help us make it private, even though it belongs to us. It's flagrantly used by the public, and they don't take care of it. They leave beer cans and all that. And it's been a frustrating issue for many, many years. And we're just hopeful that they're going to help us maybe get a keypad or something to do that. But we're tickled to death that they're here. Thank you.
Thank you. Additionally, anybody else like to come forward? Seeing nobody, I'll close public hearing. Closing arguments by the applicant. Okay, Joe. By staff.
We have nothing further. Thank you.
Okay, then there's no rebuttal. Okay, discussion by the Planning and Zoning Board.
I'm just delighted to hear that the neighbors are working so cooperatively together. That starts everything off so nicely.
That's it.
Yeah, I think there's pretty much this is one of those common sense ones that don't have too many things other than technicalities to go over, and I'm ready to have a motion if something. Unless, okay. You want to make a motion, Linda?
I move that the Planning and Zoning Board find that the following facts presented and reviewed here are competent, substantial evidence to grant the application.
As amended by staff?
As amended by staff.
By
Thank you.
staff.
Good.
Sorry.
I second that.
We have a first and a second. Do you want to call? It's a roll call.
Mr. Dagg?
Yes.
Mrs. Hillman?
Yes.
Mrs. Manous?
Yes.
Mr. Lawfer?
Yes.
Passes 4-0.
Thank you.
Thank you and good luck.
Thank you.
Thank you.
Yeah, part two.
Yeah. What we're about to have now is kind of a follow-up to that. And this one is item C on our agenda, subdivision application SD 150000003, submitted by Scholke, Biddle, and Stoddard, LLC, to allow minor subdivision approval for platting of 11 townhouse lots. And we'll go back to Form A on this one. Chairman, disclosure from Planning and Zoning Board members. Any ex parte communications? If
I
any?
have none.
I have none.
None. Swearing of the applicants and staff. Anybody who's like to speak on this, please be sworn in now if you would.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
If there's any exhibits, please bring them forward. Staff opening statement.
Yes, thank you, Mr. Chairman. As was noted, this is a concurrent minor subdivision application for platting of the 11 residential townhome lots located at 4700 Highway A1A. The request includes a platted over subdivision, and that's somewhat of a new term to maybe most of us, so I will read the definitions for the record. A platted over subdivision is defined as the division of land into two or more lots based upon and subject to the approved site plan that governs access, frontage requirements, setbacks, lot sizes and dimensions, and the location and dimensions of all the structures and required improvements. And that's what you all did in the previous applications. I just wanted to bring that forward. A copy of the subdivision plat materials are in your packet. Section 70.14 of the code requires that all approved minor subdivision applications meet certain platting and criteria and standards. And those standards were reviewed by the staff, and those standards, the staff finds that the minor subdivision meets all the platting standards. And I'll just highlight a few of those that are in the staff report. One of them is the standards that it meets the goals, objectives, and policies of the comprehensive plan. Well, the project is consistent with the zoning district, and the zoning district is consistent with the comprehensive plan. So that's found to be consistent with the subdivision plat. The next item is the minor subdivision plat is in compliance with all our land development regulations. As we mentioned earlier, and through the site plan review process, that was found consistent, and it is consistent. It's also consistent with all our concurrency management regulations, and we've identified that in the site plan. Once again, traffic was going to be reduced, and the applicant also submitted a school concurrency requirement since this project is residential in nature, and that school concurrency was found to be in compliance. The next item that was looked at, establishing development patterns supported by the private or public facilities, utilities, and street systems. As mentioned earlier, all the facilities and the utilities and the street systems will be in place. State Road A1A obviously is a major state road. The utilities and facilities were reviewed by all our agencies and found to be consistent. The development patterns are supported by all the required infrastructure that was noted on the approved site plan. An additional requirement is that in the state statutes that all subdivision platting and recording requirements be met, and these requirements included in the subdivision plat and concurrent site plan meet all those requirements, and they were reviewed by our city surveyor. The findings, the staff finds that the subdivision plat is compliant with those platting requirements. And also mentioned earlier, the site plan needs to be in compliance with the approved code, and that was found to be the case in the previous item. So with that, staff does recommend approval of the minor subdivision application for the platting of the individual 11 lots. And we did add just a few general conditions, one of which is in the code that talks about all the easements. If there are any existing easements, they need to be vacated and rededicated as applicable to state statutes. And the other is that we condition the approved plat be recorded within 30 days of plat approval. That's also in City Code Section 7012. So with that, I'll be happy to answer any questions, and we are recommending approval.
Does the board have questions of Sherry?
No questions.
I have none.
I just have one question here. On the map, the preliminary plat under project description, it talks about the prior use of the site was a 1,000-unit hotel. Is that just a typo?
Yes, it was a 100-unit hotel.
Yeah, okay,
yes.
Thank you.
How did you pick that?
Tim says it's actually 83, but
I'm telling you.
we'll give him the 100.
Yeah, the last development order that I did on that was 83 units. That thing kept changing,
This
so
is the
it's.
smallest print in the world. You saw that.
Magnifier.
Jeez. Additional questions, Sherry?
None.
Seeing none, let's let the applicant come forward and make your presentation. Joe?
Good afternoon. Joseph Schulke Vidal Stoddard for the record. Vic Lombardi, representing the owners here as well. Don't have a presentation. We're happy to be here. We're excited to get started on the project. We think we'll be submitting building permit applications within a week. We have all our other entitlements, DOT, DEP, and all that. Well, the DEP I think is coming in about 30 days. So we're very excited for the project. Can't wait to get started, and I think it'll be exciting for everybody in the area. So. Thank you for listening to us today, and if you have any questions, I'd love to answer them for you.
I don't, but I do have one to Sherry. Sherry, when
Yes, sir.
we were talking before, somehow I didn't pick this up either correctly or something. The things that are on the existing plat, the easements and things, when they create the new plat, they're all, those are abandoned. They immediately have to put them back in place. Is that right? All the.
No,
what you said?
The code actually states, and I think it's just a catch-all, just in case there are existing easements that are on the development, the project now, before this project,
Okay.
that they're vacated and the new ones take place.
So it's an automatic vacate on those. But
Correct. It's like I said, a catch-all in the code that just to make sure that if, in case there are any existing easements, that they're abandoned or vacated, and then the new easements take place with the new plat approval.
Okay.
And I don't know if you've noticed, but there's several easements on the preliminary plat.
There are some, yeah. I saw
Common
there's
areas
some.
and
Okay.
easements, yes.
Okay. So we're okay with that.
Yes.
Okay. Any well, I think we have to open up to the public now. Does anybody from the public like to comment on this application? Seeing nobody coming forward, I'll close public. Closing arguments by the applicant? None. And there's none from the staff either, okay? Discussion among board members?
Nothing.
We have no discussion. Are we looking for, I'm looking for a motion then?
I'll make a motion that we accept this and move it forward.
And do I have enough, do you want detail, any more detail on that?
I move that the Planning and Zoning Board find that the following facts presented and reviewed here are competent, substantial evidence to grant the application. Actually, there's no factors here that.
Okay.
No.
I second.
But I'd like to add, is there stipulations on it?
We didn't identify anything, did we?
No, I didn't. With the recommendations of the staff, right?
Right.
Okay.
No.
Do I have a second then?
Second.
Roll call.
Mr. Dagg?
Yes.
Mrs. Hillman?
Yes.
Mrs. Benus?
Yes.
Mr. Loffer?
Yes.
Passes 4-0.
Thank you. Good luck with the project.
Thank you. Yes. And
Good luck.
getting it done with the sea turtle season.
Doesn't look like there's anybody left.
Yes, there is one left.
Isn't that great? The neighbors get along.
Well, I actually said it was sad to see the hotel go
Yeah,
because we
it's
lost
an
a
old
lot of
big-
revenue. But this is a wonderful project to put in its place.
I think there'll be. a
Okay,
need
we're going to
for it.
move forward. Yeah, okay. The next one is a variance application number V15000006 submitted by Palm Coast Commercial Development LLC to allow a portion of a pool screen enclosure into the required side yard setback at 425 Gray Twig Road. Is there any ex parte communications here from
No.
board members?
No.
Swearing of the applicant.
If you're going to
Anybody in the
speak, if you'll
public who'd like to
stand,
speak?
please. And raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
If there's any exhibits, please bring them forward now. Presentation by staff, and Sherry, you're doing it again?
Yes,
Does
thank
he
you.
work at all?
I've already retired.
Forgive me, I'm sorry. On the job. You're okay, Tim.
That's a good answer. That's a good answer. Okay, thank you, Mr. Chairman,
Okay.
board members. Before you is an application for a variance, a petition of Palm Coast, Florida Commercial Development, LLC, for a variance for property located at 425 Great Twig Road. The requested variance is from Section 61.13B2 of our city code, screening closures, side yard setback, to allow for construction of a proposed screen enclosure to be set back 6.1 feet rather than the required 7.5 feet setback, allowing for an additional encroachment of a maximum of 1.4 feet into the side yard east side of the property. The zoning district is R-1A, single-family residential. The existing conditions, there was a recently constructed single-family home there, swimming pool, and the deck. A little background on the project. The site plan application was submitted and approved by the Planning and Development Department for a swimming pool and deck January of this past year. A screen enclosure was shown on the site plan but was not part of the approved site plan as it was not included in the development approval application. And even if it were a part of the site plan application, it could not be approved without a variance. Once again, the applicant is requesting a variance of 1.4 feet to place the screen enclosure to within 6.1 feet of the side property line. The variance would allow the screen to be placed on top of an existing stem privacy wall along the east side of the property line. The city code, in terms of variances, is very specific. It has two sections of the code that we must review, one of which is 6202, which is called the general review criteria, and 66.03, which is the specific review criteria. 66.02 is the general review criteria, and it's outlined in your staff report. Is A through G. The staff has analyzed that criteria and agrees that if approved, the staff would find that the proposed variance would not cause any of the above adverse impacts. But as noted in the staff report, the review criteria, in order to approve a variance, you need to find that both the general review criteria and the specific review criteria have been met. And that's how the staff is going to proceed in terms of reviewing the specific review criteria. And our staff report outlines that in detail, and I will summarize that for you. Once again, Section 66.03 spells out the specific review criteria that the applicant must demonstrate in order for the Planning and Zoning Board to grant a variance. And also, we want to note that all of the criteria must be met in order for the variance to be granted. So all the specific review criteria, which I believe there are 5, all of the criteria must be met to approve a variance. The first one is the required finding that the application of the zoning ordinance causes an exceptional and unique hardship. The applicant's response to that question or finding is that the application of the ordinance will not only cause exceptional and unique hardship by denying the owners the full use of their pool deck and a screen enclosure. Also, and just paraphrasing to not read it verbatim, the applicant is also saying that the deck and the screen enclosure will not alter the fact that there's already a 9-foot high wall there, and then providing for flooding and security and privacy. And the complete response from the applicant is in the application. The staff's analysis of that required finding, once again, that the application causes an exceptional and unique hardship, is as follows. The code requires a minimum of 7.5 feet side yard setback from the property line for screen enclosures. And the staff's analysis is this does not cause an exceptional and unique hardship. The code allows an exception to the minimum required side yard setbacks of 15 feet for screen enclosures, therefore providing, in staff's opinion, a somewhat de facto build 10 exception, allowing encroachment into the setbacks, which alleviates any indication of hardship based on the size and configuration of the project. The code requires a minimum lot width of 75 feet, and in this case, the subject properties, the lot width is 95 feet. The proposed screen enclosure can be built on the east property line and meet the required setback. Therefore, the test of an exceptional or unique hardship is not met. The staff did approve an alternative submitted by the property owner's architect that would have allowed the screen enclosure to meet the required 7.5 setback, but the alternative was not agreed upon by the property owner. The alternative would have been, we've had the screen enclosure attached to an angle to a lower point on the existing privacy stem wall rather than on the top of the wall. The fact that the screen enclosure can be built on the property that meets the setback requirements demonstrates the subject does not meet the test of an exceptional and unique hardship. In staff's analysis, because the property owner wants to do something on his property that is inconsistent with the setback regulations, does not constitute a hardship entitling the applicant to a variance. The second required finding is that the exceptional and unique hardship is not due solely to the owner's actions. The applicant's response to that finding is stated that the unique hardship stems from the fact that there is a 9-foot existing wall there enclosing the pool and deck and providing for security, and the applicant's finding is not solely due to the owner's actions. Staff's analysis, as we've noted above, indicates the applicant has not shown an exceptional and unique hardship. The hardship is based solely on the applicant's insistence that the enclosure be placed on the top of the wall within the 7.5-foot setback. If the owner wanted to place the screen enclosure on top of the wall, a site plan should have been prepared and taken into account the setback requirements of the code. Once again, because the stem wall was built too close to the side yard to allow the screen enclosure to be placed on the wall, on top of the wall, it's a hardship created solely by the property owner's actions. And third, the required finding is the variance will be compatible with the physical characteristics of the neighborhood. The applicant's response to that question, and I'm paraphrasing, the owners wanted a courtyard single-story design that would meet their needs, and they are providing extensive landscaping, and the stem wall is unique to this property, and the screen enclosure will be more compatible with the neighborhood. Staff's analysis, as noted by the applicant, the wall is unique and one of a kind of the neighborhood, and once again not by definition compatible, and adding the screen enclosure would increase the non-compatibility in this case. The staff is not aware of in the neighborhood where there is a screen enclosure encroaching more than the required code of 7.5 feet. Granting of the variance would create a non-conforming setback and would not be compatible with the R-1A zoning district setbacks. The fourth finding is the variance will be in harmony with the intent and purpose of the code. The applicant's response, the logic of its constructing a screen enclosure on top of the 9-foot-high wall and enclosing the pool provides elevation from flooding and security and privacy, and it is no way diminishing the intent and purpose of the code. The staff's analysis to that finding is approval of the variance would create a non-conforming encroachment in the side yard setback for proposed screen enclosure, especially as the hardship is solely based on the actions of the owner. Granting a variance just to meet the preferences of the applicant does not meet the purpose of the code and would benefit this property owner, not shared by other property owners in the neighborhood. And last but not least, the fifth required finding is that the variance granted is the minimum necessary in order to alleviate the exceptional and unique hardship. The applicant's response, allowing the construction of the east portion of the screen enclosure atop the wall is the absolute minimum necessary to alleviate the hardship. Staff's analysis, as we noted above, the staff can approve an alternative that would have allowed the screen enclosure to be placed at an angle and below the height of the wall, and that would have met the 7.5 feet side yard setback of the code. And furthermore, the proposed variance is not an exceptional and unique hardship as documented in our staff report. Therefore, the requested variance fails to meet the criterion that the variance requested is the minimum necessary in order to alleviate the exceptional and unique hardship. The staff reviewed the request for a variance of provisions 61.13 and to allow the construction of the screen enclosure into the side yard setback of the 1.4 feet. And the staff finds that the request does not meet the standards of review in section 6303 as noted above. The staff recommends denial of the variance based on the findings above and that the requested application does not meet all the review criteria of section 66.03 of the Code of Ordinances. That concludes staff's presentation.
Questions of staff? I have some. I wasn't able to visualize, maybe when, Peter, when you get up here you can, I wasn't able to visualize the alternative. And my surmise is that it has some kind of an angle where the screening is actually coming into the pool area, or the paving around the pool area.
Basically, yes, it would come in at a lower angle than the top of the
as opposed to being
yes,
up high.
Yes.
Okay, and that would meet the criteria if we did that.
But as I get back to it, the design of the whole site put them in this position to have to come in for the variance.
I understand that.
So whether or not, and I mean, even my approval of this would be kind of looking at the code and trying to meet the intent of it. But we didn't have a problem with that, and we would have approved it that way.
And Sherry, have we heard from, because I'm looking out there and I see one gentleman sitting out there, and have we heard from the neighbors on that side, and have they made any comments to you or to?
We did advertise as required, of course, just to state that for the record, we did, and we posted the signs and notified the property owners within the 500 feet of the subject variance, and we also advertised in the newspaper. Yes, the staff received several calls, I'd say approximately 10 or so, from surrounding neighbors and neighbors that actually saw the sign that may not be within the 500 feet.
Okay.
And mostly there were questions of what exactly was being requested. The people that I spoke with, they did not indicate to me one way or the other if they were for or against. They were more questions on what this actual variance included.
Okay. Did we hear back at all from the individual living immediately to that side of the home?
No, we did not.
Did not hear? You can hear from that person?
No.
Is that the abandoned house?
Is that an abandoned house?
That's my understanding.
Excuse me, sir.
We did not, that I can recall anyone saying, no, I live next door and I'm for or against. No, there were, and several people didn't give their address. They basically said, I live in the neighborhood and I'm, inquiring on what exactly is being proposed. And once that was explained, they said, okay, thank you. That was the conversation.
Could I understand better, please, about the wall that's there now? There's a reference to it being 9 feet and a reference to 6 feet.
The 6 feet is measured from the fill, which they put the fill on the side.
Right.
Okay.
I can tell you from a staff standpoint, this is something we're going to look into. The code is kind of open on this. It doesn't give you good direction on how to measure these side yard things. So this kind of thing, I think, we're letting it go on this because the way the codes read, but it's got us concerned that people could using this kind of, have much higher walls than we would normally allow. So, but it's not material to this right now.
And then, but then the reference to 9 feet is what
from the
neighboring
bottom.
property would
That's
look at.
correct.
And how does that account for like stormwater runoff?
Well, it's been taken care of. There's a drainage. It's been taken. Yes, it's been looked
site
at.
plan and all.
It's been looked
Yes,
at.
the actual stem wall is to hold the drainage on site.
Okay.
So let me see if I have this right, because I had to look at pictures. I'm not allowed to go look at the site. So the neighbor's yard is level, and we're coming into this gentleman's yard. Okay, then he has a wall that goes up, so his landscaping thing's
9 feet.
above it, but he's landscaped against that wall. So the 9 foot is measured from the ground.
The ground up, yes.
But is there 6 feet? So there's 3 feet difference between.
Yeah,
and
he's
then
got
it's 6
it.
feet
He's
above
put in
his ground level.
right, and that's what the drawings show. If you
on
look
average,
at it,
okay.
right.
So his wall is 3 feet. It's 9 feet higher to the neighbor, but it's only 6 feet high on
Yes,
his
that's
side,
my
his
understanding.
viewpoint.
And that's correct. They
Okay.
would. Yes.
Yeah.
All right.
And the setback here, normally it's 15 feet, but because they put the wall up, you allowed it.
No, the wall can be up there. The problem is
I'm sorry. The wall can be on the property line as long as it's not over an easement, so
Right.
that's not an issue. The setbacks for the main structure are 15 feet for the sides, and that's also not an issue. The screen enclosures, the code allows a 7.5 foot setback. And that's the issue here. The applicant is requesting a variance for, once again, the 1.4 feet to it. Yes.
Okay.
Not necessarily germane to this particular case, but we could have some very unusual situations in the future with this new stormwater management that we have to keep all the water on the site with some of these kind of walls being done this and to get above a certain floodplain elevation and things on homes.
Well, that's taken into account when we do the stormwater management's done when they review the site.
So
I mean, clearly it's protecting the property next to it when you have that kind of retaining wall from that
I
kind
understand that. Okay. Ken, you had a question?
Yeah, a couple questions. If you went with what staff recommended on the screen enclosure height, or how to put the screen enclosure roof up, what would be what I call the head height underneath where it's going to be dropped down, where you talked about? How many feet from the floor to the bottom, lowest point?
Are you referring to the proposed
What staff recommended?
consensus, or I guess that's not a word, the proposal that staff made? I don't know if we had any drawings per se, but it looked like
it drops below 6 feet, and
Below
I think
6 feet. Okay.
Mr. Jones has probably, if you need to look at that, it's below 6 feet, and that's my understanding why the property owner was not happy.
It's not
with that.
dimensionalized on here, what we got. There's no,
No,
I mean, there's no.
No, it's not. It was a verbal discussion, as I understand it.
But that answers my question. Then I have a question on the existing wall. It's my understanding the homeowner that's requesting the variance owns the wall. It's 9 foot high wall. We already went over that. What's the limit on height of walls that can be built within city limits? That's a pretty high wall.
Well, that's the problem in the ordinance, and that's why this will probably be the last one you see that would come through on this, because I've got to look at this. I mean, this is the way the code reads. It deals with other walls, like front yards and all.
Yes.
It doesn't get into the side yard where you measure it, and on the front wall, it tells you where you're measuring. It doesn't do it here. So it's just one of those things that we got to deal with. But I mean, as I said, I don't think this is material right now. It's an issue that came up when we did the review of the thing. Yeah.
Okay.
Thank you.
Germane is the word I wanted. Other questions of Sherry? Seeing none. Peter, would you like to make your presentation? You have been sworn in, right, Peter?
Yeah.
Okay.
I have been, yes, Chair. Thank you. I have a PowerPoint presentation that's.
Okay. Oh, this is the remote. It's on.
Thank you very much. Thank you.
Mr. Chairman, I'll be back.
Okay. I understand.
Thank you, Mr. Chair. My name is Peter Jones. I'm the architect for this project and for Palm Coast Development. 505 Beachland Boulevard is the location of our offices. And thank you very much for the opportunity to present our variance request this afternoon. I'll just wait a moment till we get set up here. Thank you. Thank you, Sherry. Oh, that's all right. Thank you. Thank you all. I hope to accomplish, well, at a minimum, three things this afternoon. One is to walk the board through our application visually, which we've put together a PowerPoint presentation, which is similar to what you've received in your packets. The second thing is to urge the board to reflect on the very unique circumstance of our request. And I think you've heard a little bit about that, and it seemed that perhaps you've addressed a couple of those thoughts. And then I ask that you find in your hearts, as much as your minds, to approve our variance request after you've heard our argument or our presentation. And with that, I'll get started. I can tell you that 2 years or so ago, when we began this project with Mr. and Mrs. Supernant, I didn't expect to be coming before you all for a variance request. Many of the factors that have gone into this courtyard home have to do with my client's concerns about flooding and privacy and developing a very creative and unique home. And so in going through the many iterations of that process, we came up with the plan, as you see here, that was brought before the city and the approval process and so on. And a couple of things that were important, as I mentioned. One was the issue of having been through a couple of storm events. Mr. and Mrs. Supernant were very concerned about flooding, and so that led us to the idea of raising the level of the house and the deck and everything else in order to accommodate that. And then came the fact, okay, once you do that and you deal with the drainage requirements of the city of Vero, which make all good sense as it should, how do we balance that? And thus came the retaining walls that run down the side that you can, let's see here if I can, well, if you just look on the north side and on the east and west side, that's basically a retaining wall that runs down the length, and then we provide for the drainage along each side. And that's where we'll get into, and you'll see the photographs of the wall itself. So in developing this idea, working very closely with my clients to try to get to the concerns that they had and putting all that together, well, it's my fault that we're here today in dealing with this. I hate to say that out loud because that we even have to be doing this is frustrating, and you know, I'll never be completely unangry with myself for having done so, but it never occurred to me that we'd have to deal with a 7.5-foot screen enclosure setback requirement. To be very, very frank and honest with you, I was so focused and have been so focused on dealing with the many important things that are part of this design, and thinking, you know, and of course noting on the site plan that we were going to have a screen enclosure, and also realizing that we've got basically a 9+ foot wall, and you'll see that in a minute, which, you know, I think this is probably about an 8-foot door. So think about, I'm standing on the neighbor here, and I'm looking at that. And of course, in my mind, if there's ever going to be any kind of a wall or a setback issue, it would have been with that wall. I mean, you know, it's the horse is sort of out of the barn, if you will, in that respect. So, at any rate, it just, and needless to say, when the screen and Josh, the screen enclosure guy, called me up and said, we've got a problem, to say that I was devastated is the least. I mean, that's the. I'm. It just. Anyway, it's not been. I hate being wrong. I just hate situations like this. But I'm to blame, and I wish it were different. And so that's why I want to walk you through our request, and well, short of begging you for your indulgence and your consideration in this very unique situation in my mind. And part of the package, you can see that I've tried to go through and take some different views of what we're dealing with, and view number one being from the east and north corner, looking along the wall, and I've got some larger images of that. Then secondly, from the little bit more from the neighbors, the view 2 and view 3 are both more from the neighbors view. So, and then going on to view 4 and 5 from the front of the house and from the east side driveway area of the neighbor's house to the east, where if there were to be any affected, largesse of an encroachment, I would certainly think, that would be where it would be of concern. So here you can see this is standing on the north property from the back of the house on the north side, looking south on the east wall, the wall in question, and that's the wall that is roughly 9 feet, and that is because if you can see, there's a little pipe kind of coming out there of the wall in the lower portion. That's roughly where the deck, the pool deck, is on the other side of that wall. So that accommodated the concern for flooding and the fill. It's a retaining wall, a structural retaining wall, and then on top of that we built the privacy wall for the deck, and you'll see that here shortly. The stakes that you see in the ground, those are from the engineering department. Those stakes were put in for grading, so that because that is a drainage way, as was noted and discussed earlier, about providing drainage down both sides of the house, and that's what that does. You'll notice the temporary structure on our neighbors to the east that seems to be within the setback requirements there.
You say, so the property line is approximately 7 feet, not where the stake is, but 3 or 4 feet to the left of the stake as we look at the photograph.
Yes, sir, that is correct. The wall is roughly 6.1 feet from the property line.
It's the shed on the other side. Because I can't visualize, is it 5 feet or 6 feet in from their property line, would you guess? I'm guesstimating?
Well, yeah, there's a 5-foot drainage easement on the east side. That's where the mulch that you see there, that's the drainage way. And you'll notice the large tree kind of just a little bit towards that's roughly on the property line.
Okay, thank you.
That helps a little bit.
Yes, it does.
Thank you. So here's another view, a little bit further, stepping a little bit further back. And again, you can see the gate coming out of the deck, and again, the wall. And that gives you a little bit of an idea of the gate there of the 6-foot-high wall where the deck is compared with the 9 feet from the side yard there. And if you can imagine, and I have a drawing that'll show that, we're asking that we basically continue up 4 feet up and then angle in with a screen enclosure on top of that. And I guess, I'll come back to that whole idea of, we've already got an opaque wall in place, and commonsensically understanding and respecting the code requirements, but it would make sense to continue that screen above that, but we'll continue on. This is from the neighbors. You can see the shed there just kind of to the left. Now I'm in the neighbor's backyard, and it gives you an idea of what is seen from the neighbors. The beautiful oak trees are going to be there forever. They're going to be there for a long time. Can't imagine anybody taking those down. There's no need for that because it's on the side yard. Those provide a lovely screen, if you will, between the Surprenant's house and their neighbor to the east. Here's another image of the wall and the that we're in this where we're asking for the variance to go. And one more, again, giving you an idea of both the wall, our wall, and the landscape buffer, the natural landscape buffer that's in place.
Now, when you go back to the photograph where now we're on the...
Oh, sorry, this one?
That one right there.
Yeah.
We're on the neighbor's property now, and we're looking at through to the wall. How far are we into the neighborhood? Is that the same big tree in front of us as we look down the...
Actually, the tree to the right-hand side probably is the one that you saw from the other photograph, and these are additional large oaks. I mean, you'll see another.
But how many feet are we onto the neighbor's property right now?
I'm probably about 10 feet. Let's see. If that's the trees right there, I was probably right about in this area right here taking. So imagine the wall being roughly the property line and where the trees are.
You're 10 feet onto your neighbor's property.
Right.
Okay.
Right.
So this is what they're looking at from probably 10 feet away.
Right.
On their own property.
Give the certain. Well, I mean, the worst case, I guess, scenario, if that makes sense.
Is there another structure on that property beside that metal shed, or that's what it looks like?
There's another metal shed in the back, but there's a residence on there. You'll see that in a moment.
Okay.
This is a view of the house, the Surprenant's house, and give you an idea of kind of the whole, I watched a video of your last meeting, and heard the gentleman presenting. This was for the carport, I believe it was, and just I think Peter got up and spoke, another gentleman, Laurel, about the just the betterment of the neighborhood and trying to so I'm the architect for the house, and I have some investment in this, but I think it's really a lovely home. I mean, in other words, we've done everything to make this a lovely place and do the right things. This gives you an idea here, a little bit further up the driveway on the right-hand side. That's the privacy wall there. The screen enclosure would be basically the cage would be on top of that, and I'll show you a diagram of that, perspective drawing of that here in a few minutes. This gives you an idea. This is from the street, looking at the neighbors to the east, and you can see the height of the trees and the foliage that runs along that line that provides a very natural visual landscape buffer from where the screen, we're asking for the screen to go, and the neighbor to the east. Again, further idea of, and as you probably saw, the Surprenants have done a phenomenal job of landscaping. They want the privacy, and have gone to great lengths to really, create a very lovely landscaped home. And here again, this kind of, gives you an idea this is roughly from roughly where that pipe is, kind of walking up to that and then taking that photograph. Again, kind of gives you an idea of a lot of the landscaping and the buffering, the natural buffering that's between the property to the east. These are images of the pool and deck of the house, and of course on the other side of that wall is where we were a few minutes ago looking at the wall, and so now you're looking at the 6-foot-high wall from the deck, and again, gone through great lengths to create a very, I believe, a lovely patio home, courtyard home for the Surprenants, and the idea of enclosing this has always been a very important part of this. And as I say, I would have never guessed that we would be standing here asking for permission to do so. Here's some more images of the courtyard. Now, if you'll notice here, and I'll come back to this, but this kind of gives you an idea of, it's on top of that wall that we would like to use as the spring line to basically come up 4 feet vertically and then angle in towards the pool with the screen enclosure. And that would make, it just would make all the sense in the world to do that. Respecting the code requirements and understanding, all of the things in consideration. However, it just, when you've already got a wall in place, it just, the things that are in place, this is, to me, such a very compelling, unique situation that at the end of the day, causes no harm, if you will. Again, looking at the wall and trying to imagine, and I have a diagram that shows you the option of bringing the structure of the screen in and attaching it to the inside face of that wall. And that's where there's grave concern because of the head height there. Jeff Serpinant is very anxious to have the landscaping on the wall. Well, you see it there, but the whole idea is that's to grow up high and provide a buffer, but for them on the inside of the wall and grow up into the screen. And having that screen now hanging on the inside of the wall, it complicates that and just makes it as an architect and designer, it ruins the whole idea, if that's the right word. And you can see it from this way too. That landscaping is all meant to grow up several feet high above the top of the wall, with the idea that the screen would spring from the top of the wall from there.
I have a question, please, if you go back to the slide, Mr.
Absolutely.
Jones.
Yes.
What's the distance from the wall to the edge of the patio there that you're showing with a little dugout?
That's about approximately 2 feet.
2 feet.
Right.
And what are you lacking right now?
About
a foot and a half?
A little less than that.
Okay.
This gives you an idea of this diagram. If we were to bring in the screen, hanging it off the wall structurally, which becomes a whole different issue. Can you hear me okay? I know, I'm sorry, I'm stepping away from the microphone. And you can see how it encroaches into the patio, to the deck area there, and that's a big concern that it takes away from the space of the use of the pool deck area there. The planting, that becomes a problem, how that deals with the fireplace, and also the flat area there. It becomes a leaf catcher, and it adds to the complications of the maintenance, and it, in terms of thoughtful and caring design, it doesn't make any sense. And I realize that's a rather aesthetic kind of nebulous consideration, but it's important. And you can see I've noted that the screen would come up 4 feet high and then angle in so that the very top of the screen enclosure is roughly 8 feet above the wall in the center portion there. This is what we're asking for, is that the screen be placed on top of the wall and just continue up. It makes all the sense in the world. And I've noted that there's no discernible difference. In other words, visually and in other words, if we establish setback requirements for very good reasons, because whether it's for air movement or just for safety's sake, there's all kinds of really good reasons for that, and that makes sense. And I respect the fact that screen enclosures, the setback requirement is 7.5 feet, and God only knows I'll be living with that for the rest of my life. But the point is that I have a wall here now. Here we are. We have a situation that it, for good or ill, like it or not, I've got a wall, and to continue up and the screen enclosure itself wouldn't be opaque. I mean, it would be barely noticed as far as the rest of the views, not only from the neighbor but also certainly from the street and all. So here's, again, this is a little diagram that shows you with the screen what we're asking for on the top and then what was contemplated below. And my point is that if you look here, that's the difference between the two. How it would be seen from the neighbor, if you will. In other words, whether I'm in at the required setback or whether I'm at the spring line from the top of the wall. And I realize that doesn't diminish the importance of the setback requirement and the reason that we have those kinds of rules and regulations. I respect that. But that's why I wanted you to think of this in terms of its unique circumstance. And this gives you an idea of how that would work from the inside. You'll notice that it allows the screen to spring off the top of the wall, and then the kind of sketch gives you an idea of kind of how that would look. I realize it's a bit of a bird's eye view, if you will, but it gives you an idea of why we're asking for this, because it makes good design sense. It's the right thing to do. It just anyway. I wish I could explain it more eloquently. And again, so this is what we're trying to preserve: is the beauty of the deck that has been created. And I thank you for your consideration, and I'll be pleased to answer any questions.
Are you going to call anybody else, any witnesses at all? If you're going to speak at all, please go up and be sworn in, sir.
Come on.
No, he was sworn in. I just need him to introduce himself.
Okay.
Yeah, we're full-time residents here.
Okay.
When we started with Peter in Palm Coast doing this project, when we started doing this project,
your name, please.
Jeff Serpernot.
Thank you, Jeff.
Okay. I chased this lot for 5 years because of the dimensions of it and the depth of it to be able to put this courtyard-style home on it. This is a mistake. I relied on Palm Coast. I relied on Peter, as he's nicely noted. And we thought when the first site plan was approved, which was probably 18 months ago, that it showed the pool screen on that too. So to us, we didn't try and pull anything over on anybody. We just tried to have this house designed and put on here. But I would ask for your consideration on it. I appreciate the answer on it. Okay, thank you.
Yeah. Any questions of Jeff? None. Thank you.
Could I understand better the alternative that had been proposed?
Well, the alternative would have basically brought the screen down lower. I mean, there are different ways they could have done it. They could have, they have some room there where they have to get rid of some of the landscape and redo that, and they could bring the screen all the way down to the ground by itself. One of the things that we're forgetting here, our definition, and we didn't get into this, I was given a break, screen enclosure does not have an opaque wall. It's supposed to be a screen wall. So clearly just being able to attach to the wall is not exactly what the definition here. I think that they expected screens to be clear, that you could see through them, and that's why one reason they could be close to the setback line. But anyway, getting back to it, the one we did look at that Peter showed to me would have been to come down somewhere down the wall, and he pointed, I think he showed that up there. But there's another thing, they could have redone the screen, but you would have lost some of the landscaping and the, because it's already been designed. So,
Well, let me get back and before we start back and forth, let's get the open to the public first.
Yeah.
Is there anybody from the public who would like to speak? And it's open. Seeing nobody, we'll close public. Now we can go back for closing arguments and et cetera with Tim, and a discussion with Tim and Peter.
Okay, you want to?
Do you have questions of Peter or Tim?
Tim, my understanding just now is that the original site plan was approved and the screen enclosure was showed on the.
It was shown on there, but it wasn't part of the application.
Okay.
In a good world, we normally X those out, but the point is, it couldn't have been approved that way. So just because it was shown on the site plan, it was not part of the application, or the staff would have reviewed it closely. It was not shown as part of that application, even though we say a lot of things on drawings. Some of them, you just saw one you approved a little while ago, they have things on there. And that was not part of the approval, or the staff couldn't have approved it at that time. So that's moot, and that's why they're coming in for the variance.
And one other thing, where the wall is placed now, they're asking for a 1.2 foot variance. Is that correct?
1.4.
1.4.
Yes.
Now, if placed on the wall, if the wall is in compliance now,
well, then
where does the 1.4 come?
The 1.4 is where the wall is. So the wall is in compliance. Remember, you can have a wall, but a screen enclosure is 7.5 feet from the property line, and that's what the issue is here.
Okay.
That they would want to put the. Okay.
Thank you.
So I have a question. So your 1.4 needed. So the screen enclosure, you couldn't put the posts up against the wall on the inside.
Well, I haven't measured it, but the way there is a difference there because you could angle it down. So there is, we'd have to look at it. You could put the posts in there. You would probably have to get rid of some of the landscaping and the pavers that have been put in. See, this has all been built. You understand what I'm saying? So you're dealing with a built environment, yes.
Could we go back to the slide that showed the wall, please, Mr. Jones, with the planters? There, one more, I think. Nope.
I can go back to.
Well, there.
That one.
So looking at the slide, Mr. McGarry, where the green plants are on what I call on the inside of the wall, if you went behind the plants and put the posts right up against the wall, do you have enough room then to go up?
No, I don't know if you have enough room then because of the angle. Because you still have to go back a little further. If you angled it down, I believe when Peter showed me the drawing,
yes,
it would be down. Yes. It would just make it at the 7.5. So somewhere along there. And without the drawing, I mean, it's a little. But for the whole screen to go up, you would need to have it back a little further, I believe. Yes.
Okay.
Does anyone know the width of the wall right now?
It's got to be at least a foot.
It's
that you're talking about
the existing wall.
It's an 8-inch block wall.
8 inch.
So there's 8 inches right away that.
Don't you have stucco on either side?
A little bit of stucco on either side.
So it would be more than it'd
probably
be
closer
wider.
to 9.5 inches.
9.5.
So basically 9.5 inches. So basically, then you need a few more additional inches to make the 7.5.
Correct.
Well, actually, it's a little bit beyond that. It ends. The problem is that the recognizing, if I may, the face, perhaps. The face, if you see there on the furthest dash line on the inside, that's roughly that is the 7.5 foot setback line.
Where the beginning of the red line begins? Right next to the gate?
Let's see if I can try to.
I would have thought you were right. I thought it'd be
Yeah, that's what I would have thought. Okay. Right.
So the problem is that the structure of the depth of the beam, the frame, so I'm already inside the face of the wall, and then I have the depth of the frame itself, which encroaches even further. So I end up being roughly to the. You'll notice that. Well, you can't see it's hard to tell the line, but let me show you this way. You see where the frame would end up being close to the face of the the fireplace, which is roughly in line with the front edge of the plants. So in other words, to be able to come in to the depth that I need to meet that face, the face of the screen at the setback, then the depth of the structure, that's necessary. Now I'm encroaching nearly to the edge of the planter.
Okay.
And that's the concern of Mr. and Mrs. Surprenant, is that it just takes away from the deck. And I don't want to diminish the alternatives, but I'd like to just ask for your consideration of a better design solution for all. Thank you.
Was that your closing argument, if we want to call it that? I have to go through a procedure here, so we got to.
I could get on my knees and grovel.
No, I don't think we're going to ask for that.
I just, again, this is to me and to us and to the Surprenant, certainly, it's a very unique situation. And I realize that, one size doesn't always fit all in our regulatory world. I've been in this business for 30 years and been a city planner and worked in planning departments. And so I understand and respect that thoroughly. And that's always the hard part, is that you have situations like this which are terribly unique. And so I ask that you consider that, and thank you for that consideration.
I have a question, if I could, Mr. Chair.
Well, yeah, go ahead.
On the variance, is this, and I guess it would be to the attorney representing the city, if a variance is granted, can it be granted with conditions?
Yes.
Okay, thank you.
But remember, that does run with the land. It's recorded and runs with the land.
Understood.
And remember also that as quasi-judicial judges, you need to make a finding on each one of the items in 66.03, as well as 66.02.
Okay, thanks.
This sets a precedent, doesn't it? For the
No, it
neighborhood?
doesn't.
No?
No.
No.
Is there
I
a
can
closing?
find you the case on that.
Is there a closing argument by staff?
The staff's recommending denial. The applicants even admitted that basically they put themselves in this situation. I feel sorry for what has happened, but they put it on themselves, and they should have looked at that. There are other design alternatives they could look at. I know it's a hardship, but just think about it. If because you want to do something, you go and get approval, and then you come back later, oh, I can't do that because of this, and come in for the hardship, it doesn't fly. And I'm sorry, it's I do not believe they meet that unique hardship case. Just because you want something and because you did something that led to this action. I mean, they had a piece of property that they developed, should have followed the code. The codes are important. If you give them a variance here, then what about the other people in that neighborhood? If a variance is needed, then change the code if that's the case, rather than come through with a variance. I don't think you need to nickel and dime the code you create some real issues there. You should change the code if that's the problem in this case. And that's the only way to resolve this issue to their satisfaction, in my opinion, because I do not believe they meet this criteria.
Do you have any rebuttal to that?
I do. Appreciating and respecting Mr. McGarry's observation, and not to disrespect that, I just believe that we didn't willy-nilly do this. This was done. This is my mistake. I can't get around that. I have to be honest about that. But it wasn't done with the intent of coming back and surprising anybody or trying to get around something. This was, as I said, when you build a 9-foot wall and you've got a screening, and all the other sorts of things that went into the design of this house, it didn't even occur to me that we would have an issue with a 7.5-foot screen enclosure setback requirement. Why 7.5 feet? Why, and yes, I mean, you can go back and change the code, but here we are in this particular situation. We have a 9-foot wall in place already. It's to allow this very unique variance request doesn't set a precedent. It makes for good, thoughtful planning and design, in my opinion. And again, thank you so much. Thank you.
Any rebuttal to his rebuttal?
Bad decisions don't set precedents. That's true.
And I wanted to follow up on that precedent with the case that says an applicant's variance request must be reviewed on its own merits rather than on the basis of previously approved variances in the jurisdiction. Previously issued variances, as this one would be if you issued it, do not establish controlling precedent or constitute a basis to sustain other variance applications. Okay. So it's good because you can look at everything on a case-by-case basis. Okay. But I think I need to add two more cases, and one is from the Naman case, which is a third DCA case. Appellants are deemed to purchase the property with constructive knowledge of the applicable land use regulations. And another case, Nance, from Fort Lauderdale, this fourth DCA, which is our district. It is the land and not the nature of the project which must be unique and create a hardship. The land, not the project.
I think we're ready for our discussion then, unless there's any questions of...
I have no more questions of staff at this time.
Who would like to open a discussion?
My heart goes out. It really does. Really does. But, rules are rules. I'm finding it curious now because this is the second thing on Great Rig that we've seen recently. Is there a situation that maybe they should be talking about an overlay district with their own regulations?
I think this is entirely different. Let's hope so. We get more Great Twig, but no, this is a different situation you had before.
Linda?
I feel very bad for them. I really do. And I'm trying to go over the 66.02 and try to bring out something that would help us to come to a decision that would please the applicant. I don't see any imperil to public safety. I don't see overcrowding of the land. I don't see imperil of general health and welfare of the inhabitants of the city, so
I think staff agreed that there was no issue there.
Correct.
Yeah. That's correct.
It was the next one on the specifics. Right. And every single one under specific, the required findings must be noted.
Right.
Ken, you got a comment?
I also feel bad for the folks. You have a 9-foot wall there already. And according to what I'm being told, it wouldn't work putting the screen enclosure metal beams on the inside of the fence. Is still not enough room, even if you dropped it down the face of to the side that I'm looking at with the bushes. Still doesn't give you the 1.5 feet that you need with the 7.5 foot setback. If you put the screen on top, I don't really see too much harm in having the screen with the 9-foot wall. Obviously, there was a mistake made. And what I'm hearing, there's no way that we can do this through the staff's eye except dropping the height of the screen roof down. You had said 6 foot. So.
Well, you'd have to redesign more than that. It could be done other ways, but they've already got, their outdoor fireplace. They've got other things that would have to be moved.
Ken, you and I are pretty close. I'd like to just express my feelings on this one now. I'm going back to a little larger question. We as a board sit here and try to make reasonable decisions under reasonable circumstances. And when we see somebody who definitely, I can see Tim rolling his eyes already at me, but I believe that's why a board exists above the management of the city sometimes, to make the decisions that isn't going to change the world, but it can make somebody's life a little better. And the neighbors, in this case, if they would have come in here and opposed it, I'd have been real quiet. And but I think we have to apply practical applications also. And I think there is a hardship. I think the cage, and I'm going to consider it a hardship. You see, a hardship is not something you make it difficult to work, but a hardship is a time when it isn't. I'm defining it as something it doesn't have to be, that we can make it a little better for somebody, and it doesn't impact anybody else on the negative side. If I thought this was negative towards somebody else, then I would say no, because that would be infringing on somebody else. But I don't see the negative or the downside to it. And I want to know that codes are, the reason they have boards above codes is to make rational decisions here. And I can't see anything irrational about being in favor of granting this people what would make their home a better place. And if you look at the home that we've seen here, this is definitely a wonderful, beautiful home in our city, and I encourage more of this. Now, if I lived on the side that has the 9-foot wall, I wouldn't be very happy right now. I admit that. I would not enjoy that 9-foot wall being there, especially when I see it not landscaped. Okay? I can see that 9-foot wall. I don't like that, and I would have never approved that if I had the opportunity, because I think that would impact the neighbor. My only suggestion might be that since we're allowed to put a criteria on it, I'm going to make a suggestion that we suggest some landscaping to the outside of that wall, and I'm going to be in favor of granting them the variance. If that's not right, then I'll withdraw that.
What bothers me very much is the fact that if I were to be the neighbor, or I purchased the property next door, what am I looking at? I'm looking at a 9-foot wall and then a screen enclosure that rises above that. And I don't see that landscaping is the cure on something like that.
Well,
and then
I'm sorry.
what if the neighbor put up a wall? Does it become a city of walls? An area of walls? How much do you leave between the properties?
We're not going to do anything about the wall, though, honey.
I know, but we're
there.
talking about rising above.
It's sloping and immediately sloping away from it, and it's 9 foot high. Are you really going to see
Well, we're
it?
not sloping, are we? That's not on here. They didn't approve of that angling.
They did
it's vertical, 4 feet, and then angles in, correct?
Yes, they did show a picture of the screen enclosure, the way it would be put on the wall itself. Question to the city attorney. If this is passed, again, it's passed on a case-to-case basis, am I correct? It would not uphold through any other party that might come
But as I
in
said
front of the
before,
board?
you need to make a finding for all the criteria in 66.03.
Okay.
Because you base your decision on the competent substantial evidence and the law is that criteria in the zoning code passed by the legislative body.
So we have to say that, yes, it causes an exceptional and unique hardship.
Yes, and in fact, when Tim drafts a variance or when we draft a variance together, it will actually list all of those and make a finding that you all found all of those existed.
And also, we have to find that it's not due to the owner's actions.
Yes, ma'am.
And in that case, it wasn't the owner's action. It was the owner's responsible for who they hire. I understand that, and they have recourse if necessary in that regard, probably. But
and that it has to be compatible with the physical characteristics. It just seems to me if you're making a statement that this is unique, that departs from being compatible. In harmony with the intent and purpose of the code, we have to find all this.
Yes.
Yeah.
Well, what I'm thinking of, actually, I have a question, if I may, to Mr. McGarry. What's to have headroom with this, where people could walk underneath the screen? How far down could we drop it Forget what you see as the design.
I'm not trying to design this thing because it would have to be redesigned if you deny the variance.
All right.
And
That's fair.
as again,
That's fair.
okay, there
fair.
are ways it can be done.
Okay. With a 9-foot wall, if a variance was granted, and the folks from their side of the equation pointed out the hardship, a mistake was made. They didn't know. As far as they went in, everything was moving the way it was supposed to, and then this was brought out in the open that, hey, this is missing the setback. If you did the variance with conditions where the wall that's blank on the blank side now with landscaping and improve it would actually be beneficial to the neighbor that's looking at a big 9-foot wall. Even if you had whatever the height looks like, maybe 4 foot above the wall, I think, with that screen enclosure where it begins to go up on an angle. Looking at a screen's not so bad, but looking at a 9-foot wall as it stands now is pretty bad. So if we could set a condition on it, to me, I think it would help the other property owner looking at the blank wall.
I kind of agree with you, Ken.
You all remember the last one of these that we have, I read you the definition of a unique hardship. I just wanted to read that one more time.
Okay.
A unique physical characteristic of the land and not an impermissible self-created hardship. So it's a unique physical characteristic of the land as it exists.
So what I'm hearing from the attorney is this board right now, we have to rule according to the law that's in front of us. Period. There is no flexibility, is what you're telling us.
No.
So even if we wanted to help out, can't do it because that's not under our jurisdiction.
Well, the thinking of it is that the legislative body passed this as an ordinance, this particular setback after public hearing, public opinion.
Mhm.
It was passed, and a variance would alter that.
Understood.
And so that's why the variance criteria is so strict.
Okay.
We might find an exception with one, but it has to be every single one.
Right.
Yeah. My heart definitely goes with, them.
So it really leaves the board with actually, we don't have a choice. Which I really do feel bad for these folks submitting the application. Our hands are almost tied with according to what we were told by our attorney.
After reading all the criteria of 6603, there is only one that you could
I think every one of us is sitting up here saying, let's find a better way to do this,
There is only one that you could say, and that would be the minimum necessary variance exception. If that's it. The rest would be a no. I mean, it doesn't cause an exceptional hardship. And you can go down and read them all, and there's only one that I feel that would bring help to the applicant. All the other ones are going by what we're supposed to do by law.
Back to the staff analysis on number 5, and that's the best that you can do as far as to help them out, Mr. McGarry?
Well, I love to help them out. I tried to help them out when they came in with the alternative, because even that's kind of pushing the code, as I read to you that. So I was trying to avoid their having to come to a variance. I mean, we always try to do that, and they knew fully well, the staff would not, that we had a problem with this before they went into it. Okay, so we try to do those things outside having to come before you all.
This reminds me of, I built a self-storage in the Northern Virginia area, and the rules were such that they made no absolute sense, but I have to tell you my unique situation. You only have to wait 1 minute to hear it. They wanted me to put on the outside of the roll-up garage doors the braille letters so that the blind could read the letters from their car as they drove by. So the blind are driving by, but they stop their car, get out and go over and feel the braille letters to see if it was their unit, and then they get back in their car and they know where their next unit is so they can stop at. So, and they maybe put these up at $11 a piece. And the reality was that these kind of things are sometimes and we have to be reasonable, and I think, and that's where I'm still at. I see a reasonable exception here that this was basically something that happened. It's not impacting anybody. I think that's what my job is in addition to what I'm to read every rule. And everybody interprets everything. I can get 4 judges that will say that I'm right, and I'll get 4 judges that says I'm wrong. So my interpretation is my interpretation, and nobody can disagree with that except me. So I am in favor of granting the variance, and I think I'll leave it there.
Can you give the reasons why, as the attorney needs you to state?
I found them that they don't impact anything that's negative here as far as I'm concerned.
Well, there's not much I can say except that you do have to make a finding that 66.03A 1 through 5 are all met. Based on the competent substantial evidence before you, which includes the staff report, the testimony by Mr. Jones, the testimony by his client.
Number 2, the exceptional and unique hardship is not due solely to the owner's action. So solely is it was helped out by his architect.
That would
No.
Okay, you say no, but you interpret it.
No. What I'm saying is the owner was given an alternative to come in without having to go to variance, and the owner rejected it. So the owner took full responsibility for this variance request. I just want to be sure the facts are on the table, and that was in the staff report. I'm not arguing, Mr. Chairman.
No, you can argue all you want, Tim. That's part of our deal. I just don't think I'm doing the right thing if I reject it, that's all. So I'm ready to call the question if necessary, unless there's additional discussion.
We'll need a motion. Was that a motion that you made earlier?
I'll make a motion that we accept the variance. To approve it. Do I have a second? Hearing no second, my motion fails for lack of a second.
I move very reluctantly that we accept staff's recommendation and deny the variance for the reasons that we cannot support any of the findings. I mean, that we do support staff's findings in the legal sense of it.
Do I have a second to that motion?
The board needs to make a decision.
That motion is declined because of a lack of a second. I'll go back and make my motion again. I make a motion that we accept the variance, that we met all the criteria, I believe, and we should grant the variance.
I'd like to add to that is, since we can put conditions that they landscape the outside of the wall, or what would be the direction of the wall, the blank side.
I will modify my recommendation to include what Mr. Degg has added to that. Do I have is that a second then, Ken?
Yes.
I have a second. I'd like to call the question. I'm sorry, further discussion?
I can't support that.
I accept that.
Okay.
Is there further discussion?
No.
I call the question.
Mr. Dagg?
Yes, for the variance with the condition.
Mrs. Hillman?
No.
Mrs. Manous?
No.
Mr. Lawfer?
Yes.
It fails 2-2.
Thank you. It failed. I'm sorry.
Thank you.
The next item on our agenda for today is what? Planning and zoning matter. Are there any planning and zoning matters?
Mr. Chairman, we've got a full agenda coming up next week, next meeting. We have an annex.
Next week or next meeting?
2 weeks from now.
2 weeks from today, okay.
Seems like we're already into next week.
There was a public notice today.
It seems like they're coming every
You already
week
got
now.
Fast and furious.
Yeah, we have an annexation report for an annexation on 43rd Avenue. We have a rezoning coming in, another variance request, and how we love variance requests. A text amendment for a change in some uses. And just to give you an update, we're working on the comp plan update, but it's kind of slow. So I don't know if we can meet the deadlines, but we're going to keep hammering away at it. So
Keeping us busy, are you?
All right.
yeah, it's tough when you're dealing with all this and then having to write. And I do have help with a consultant, but I have to also review their work and making sure they're online. So.
How's it going with working with the consultant?
It's okay, but we hired a consultant more on an hourly basis away from here, so there's some problems with that. Okay. But I wasn't giving a ton of money to work with this, so I'm doing what we can. So, and they're helpful.
Okay.
Board member matters?
Yeah, just going back to, this is the second time now with Gray Twig. Are we looking at more things coming up there?
Well, I mean, as I said, the other Gray Twig had to do with a setback with, extension of a garage,
right.
However long that was, and we weren't certain. They never told us.
They're kind of like revitalizing the area. Should we be looking at something?
Well, that wasn't a brand new house. This is a brand new house. It's a little different. And I believe that, Sherry, if I'm wrong, that part of Gray Twig had smaller lots. Yes, they're the ones that had
as long as I remember.
Yeah,
right.
You remember, and they didn't have to have the same width, and that was one of the issues. They only needed a 10-foot setback rather than the regular 15. Right. So it's a different part of Gray Twig than this.
Mr. I'm sorry, I didn't mean to interrupt you. You said it was a new house?
This one.
Yes.
And the wall was built new?
It was part of the original approval when they did the site plan for the house. I believe they did some other minor amendments. Sherry had a whole list of things.
Yes. So the wall was not pre-existing, it's new?
No, it was brand new.
That's correct.
So we can build 9-foot high walls now?
No, my staff is not going. You're not going to see another 9-foot high wall.
I'm curious about that. As far as it has nothing to do with what we just looked at.
No, and I after I looked at it again, on approval, it looks like. I looked at the code. That's why we haven't made a big deal out of it. But we're not going to. We will address that if we even have to change the code. We can't. I don't think 9-foot walls is what the intent. Of our code.
Not to my recollection.
Because there was something on the other
walls.
side of the property had a large wall also.
Was that not part of the elevation, though, that they had to?
They showed it on the plans, and and be honest with you, I signed the site plan, and when the staff looked at it, they showed 6 feet and then 3 feet. But if you look at the way the code reads for side yard walls, they don't get into how they measure. They don't talk about measurement. That's missing in the code. So I'm going to have to take my authority as planning director, and this has been approved, so we're not going to go, not after they've done it. It'd be equitable estoppel kind of thing. We're going to go ahead, and when we get new ones coming in, we're going to be sure that isn't done. And if somebody, challenges, I'm going to try to change the code, but, it takes a while to do that. But we aren't going to allow those kind of things again.
I also agree with that. I thought the wall was inappropriate. It may have been a wonderful thing for their yard, but I think it impacted the neighbor significantly. Could have impacted neighbors significantly.
And yes, I agree. Yeah. I mean, we have. I didn't believe we'd have anything over a 6-foot wall.
That was my understanding, and so now what my ear is hearing is right now. The code doesn't say you can't build a 9-foot high wall.
No, it really is. It doesn't tell you how you measure the wall like it does for front yard.
It's the measurement end of it. So if you want to
nebulous, is it nebulous?
Yeah, it's just vacant.
It needs to be rewritten to update the.
It should be rewritten, but I'm going to make an interpretation until we get it done. So, and if people want to appeal that, they can, but we will clean that up. That we don't want to have that.
There's nothing pending right now that we have to be concerned about.
No, we haven't. I I was surprised when I saw it. But again, I have my signature on there, so I'm just as culpable as everybody else.
You're like Mr. Jones right now. You wish you might have done something a little bit differently, right?
That's true.
But it still required a variance in the beginning.
Right. So going forward
That's correct,
on the wall height,
Yes, sir.
since it's going to be a code change, that will have to be vented with the public hearings and all? With
It
the
would
height?
have to go through,
So that's
through
the next
public
step.
hearings. That'd be the next step when we get to it. But I will try to handle it administratively until we get to that point.
And so that's already, so it's
Are you
clear
going
in
to
my...
be challenged on that?
Yeah.
Well, I might be challenged on that,
Yeah.
and there are ways to challenge that. They could have, in this case we just heard, they could have challenged us on the permit itself that we actually had approved that. You know, that could have been a
We
challenge.
might still get that
differently.
also.
And then
Is it
we
still a
could,
possibility?
it's a possibility.
Okay.
So that's on your work schedule now to work on this wall
Well,
height.
yeah.
Well, the reason
What
I'm
I'm saying,
the reason
I-
I'm asking going forward, right now, as you
Yeah.
know, we're doing a lot of construction in Vero Beach City.
Yeah.
This could come up again where you could
That's
have
about
9-foot
it.
wall, 10-foot wall, depending on how you fill it
Well,
in.
the staff's been alerted. We don't have any other that we know about in the
Now.
process or in the
Right.
stream.
It's
so,
in the radar now.
Yeah, it's in the radar
Yes.
now. These
Every
things
single wall we see on a plan, it flashes red.
flashes
red. Stop,
after
stop.
that. Yes, we totally agree that I was, I said, holy goodness. Okay, Mr. Chairman, was that Fairfax County that put it to you? That's usually Fairfax County? Right? Hey, you got a rich county, they're going to do a lot of things to you. That's correct. And we will be busy.
I just lost the whole dais.
Okay, that's probably good. Yeah.